Your Lordship, kindly, it is regarding the order, the allotment of site by the KHP. Contempt petitions has been filed by the party because it was allowed by a single judge. The writ appeal has been filed and the matter has been posted on 1/7. So the matter may be taken up today. It is contempt has come in the 31, serial number 31.
We'll take.
Yes, please.
Yes.
My lordship, the serial number 35, motion for adjournment, and the petitioner,
35.
please. I will inform the learned counsels for the accused.
Contempt.
Please,
11th July.
please, publish.
My lords, in a serious matter, review petitions have been filed and it is dated for hearing on 12th of July. If the same can be tagged and can be heard together, my lords, we've also
Which?
filed review petition, my lords.
To be tagged with what?
On 12th, there are series of matters. If the same can be tagged on 12th.
12th.
Writ appeal, my lordship. 1 month back, office objection complaint, not at list, my lordship.
Not listed.
Yes, no,
After 1 month.
yes, my lordship.
11th July.
11.
July.
My lordship, serial number 41, my lordship, short accommodation. Pardon me, serial number 41, my lordship,
What do you want?
for the petition, my lordship,
What do you want?
short accommodation,
Accommodate.
41, my lordship.
23rd July.
Oblige.
Lords, the matter is before MGS Kamal. The matter is before MGS Kamal for 12th of July. If it can be tagged for this one.
Yes, I said, you said yes. Mr. Counsel. That is matter. Yesterday it was brought to my notice.
Please, ma'am.
So it will be posted when the honorable judge is here. He is
Please.
Harvard, right?
Please, ma'am.
So
It's
whenever
just for
the-
tagging matter, ma'am.
Whenever he is here, it will
Please.
post.
Please.
My lord, contempt petition, my lord. It was filed in the 2023, my lord. It was filed in 2023 and it has not come before your lordship. It has not come before your lordship after just, it has come only once before your lordship. It will come again second time, my lord. No, my lord, we have only, maybe posted in the week itself. 25th of July.
My lord, serial number 44, my lords. I seek an adjournment.
44. What do you want?
44. 34. Yes, for an adjournment.
When do you want? 22nd July?
Mine is serial number 31.
What to do? What is to be done?
31. It
What
may
is-
be posted on 1/7.
1/7.
My lords, may it please, my lords. My lords, there was an order passed by this Honorable High Court.
31 will go to 1/7.
My lords, there was an order passed by this Honorable High Court dated 30th of January, pursuant to which an order closing my factory was quashed. And the Pollution Control Board was directed to issue a show cause notice and adjudicate the matter. But till date, they have not acted upon it, my lord. We have filed a mandamus seeking a time frame to be fixed. That's all the issue is. We had filed this matter on 11th of June, my lords. It's not yet listed. So there's an urgency because the past 5 months my factory is closed and there is no avenue for me. So hence, my lord. Second or third, if my lords may be pleased to.
25th July.
My lords, it's very far, my lords. I mean, 5 months have already elapsed. Simple, it's just the authorities may be just directed to act within a time frame. That's all we are seeking, my lord.
10th July. 10th.
Obliged.
Your Lordship, serial number 40, Your Lordship.
40.
40, yes, Your Lordship, 40.
Yes.
Your Lordship, I'm appearing on behalf of respondent, Your Lordship. I have already informed petitioner. I have to file a statement of objection. 3 weeks time may be given, Your Lordship.
3 weeks time, 24th of July.
Much obliged, Your Lordship.
At the request of learned advocate Miss
Swati Ashok, Your Lordship, appearing on behalf of respondent number 8 for
Lawrence
Karnataka.
Institute
Waqf
for
Board.
respondent who wants to file rejoinder from a stand over to 24th July.
Much obliged, Your Lordship.
May make a submission, serial number 11. I seek on accommodation. I seek on accommodation in serial number 11.
My lord, there's nothing in this appeal.
Let us see.
No, I
Anything-
will address argument kindly one short accommodation maybe.
And when it is called out, we'll grant. When it is called out, we'll grant accommodation.
Matters, serial number 1, Mr. Vaibhav Ravi Malimat.
My lord, appearing for the petitioner, the contempt, my lord, is against the order of the learned single judge.
What is the content?
My lord, what has happened was the learned single judge restored the suit filed by the accused, subject to the payment of rupees 2 lakhs as cost to me.
Go to the suit process.
My lord,
Go to the judge where
No,
suit is
the
pending.
learned single judge, my lord, passed an order before this in the Honorable High Court.
You're aware it, read.
Yes,
You argue, don't explain to the court.
my lord, there has
You're
been,
aware of this.
yes, there has been a willful disobedience by the accused.
Lawyers only argue, not, they don't teach the court. And we are not like to be taught. Argue the matter, where is the direction not complied with?
Yes, my lord, the judgment, my lord, starts at page number 12. May I persuade your lordships to kindly take page number 21, your lordships, of the judgment?
Read it.
Yes. Lord, in the second paragraph, my lord, page number 21, the impugned order dated 30/7/2016, passed in MA number 49 of 2013 by a learned second additional district and session judge Mysore, and the order dated 21/5/2012, passed in miscellaneous petition 54 of 2012 by a learned second additional civil senior judge Mysore, are set aside, subject to payment of cost of rupees 2 lakhs payable to.
What is not complied with?
My lord, he has restored the suit without payment of rupees. He has, my lord, restored the suit. The notice for restoration is at page number 24, your lordship.
Which part of the directions are not complied?
My lord, this part, my lord, the second paragraph, where he is required to pay cost to me before seeking restoration of the suit.
Which is the cost 2 lakhs?
Yes, my lords,
Not paid.
not paid, my lords.
Heard learned advocate Mr. Malimat. Notice returnable on 23rd July.
Yes, grateful, my lords.
Serial number 2,
I represent,
Yes.
may I pray my lords to kindly peruse page number 17, ink page number 17. The operative
Interim order.
True.
No, sorry.
but with the liberty, since with liberty to agitate before the,
Impugned in this appeal is interim order and the proceedings of the writ petition are pending at large before learned single judge. The court is not inclined to entertain the appeal. However, all the contentions which could be lawfully urged by the appellant are kept open to be advanced before learned single. judge. To be
it
considered
is
in-
not before the learned single judge, my lords, it's a division bench in the first appeal, therefore that one.
Considered in accordance
Division bench in the first appeal.
without expressing any opinion.
The appeal is not entertained accordingly.
Education matters, seal number 3. Prabhu Godinji.
Not the petitioner is a meritorious student, but in order to pursue not the professional courses, not applied for the not the NEET examination and
Which course you are pursuing?
not
Which course you are pursuing?
not medical course, not
Medical.
Medical.
Which branch?
not which branch, not they have to allot them not the
And
first
what is
course,
the, what is the disability?
not
What is the disability?
the 40% is the not
What
the
is that? The physical, eyesight,
eyes, not
hearing,
eyes, not
eyes.
40% not even though not the government has issued the certificate not and UDID call also. Not subsequently on not physical verification, they stated that 0% as good as not the nil
You
disability.
must have undergone the fresh medical examination.
Yes, not they called for the lot of the age. May I take my notes to the
So as per their procedure, you must have undergone the
no
fresh.
notes. I will take notes. May I take note of the page number not 21, not the annexure B.
Page?
Not the page number 21, not the annexure B.
Yes, disability.
Not this is the disability certificate issued by the Department of not the Endowments, Persons with Disability, Ministry of Social
So
Justice and Endowment.
this you produced
This I have produced.
before, along with your application.
Not,
Along with your application.
yes, not along with my application, not,
What interviews were there?
the fact is this, not.
What was the
I-
next, what was the next stage?
Next is not, I have not the passed the not the NEET examination. I scored well, and not they called me for the not the physical test. Not I went there. I went to the Minto Hospital.
They called you in physical test
Yes, not.
and you were again examined.
I again examined.
Disability.
They say that
disability-
not they
Hey, listen, at that stage, disability was found to be 0.
zero, not. In fact, not the doctor said not he 40% disability. He said. Not so while not the issuing not the on uploading the not this disability list.
Yes.
Not they stated 0%.
Where is that 0% certificate?
Annexure.
Not annexure not the
H, your lordship.
annexure A, my lords. Annexure A, my lord, the page number 13. Not the second vertical line.
No, certificate, Mr. Counsel.
My lords,
Where
page
is
number
certificate?
13.
Where is the certification about 0% disability?
That is not that is the not the annexure A, my lords, page number 13.
Page number?
13. Page number 13, my lords.
13. Oh, so
That is not the
what
not
is your
second
name?
vertical line, my lords. My this serial number is
Sir
186.
Shreyas.
Yes, my lords.
Where is your name?
Shreyas. My lord, 0% they have shown, not eligible, not they have mentioned.
This is a tabular form. We want certification.
But they will not issue certificate, not this, they will upload to the not
Where
the
is-
KEA
where is-
website.
Where is your name even in this table?
My lords,
Where your name figures in this table, Mr.
yes, my lords, my lords, page number 13, vertical line, second vertical column line, not so serial number 186.
180?
186, my lord, second vertical line, serial number. Shreyas, my lords, Shambulingappa,
You show the serial number.
my lords,
Not-
105, my lord.
105, your lordship.
105, my lord.
105.
One not. Not this page.
Page number 13.
Page number 13. 105. Shreyas.
Yes. If my lordship permits, my lord, I'll keep him present before this honorable court. My lord, he is having my lord the 40% deputy on my lord seeing on bare eyes, my lords, we can.
Lord learned advocate, Mr. What is your name? Tumbigi,
Yes, my lord.
PB. Notice returnable on.
My lord, that the counseling is there, my lord. Within a week, my lord, they will take counseling, my lord, they allot the seat. My lord. If that is done, my lord, so you will lose the, my lord, the.
2nd July.
Lord.
2nd July.
Lords, meantime, my lord, they may, any time, my lord, they may take up, my lord's counseling.
2nd July.
Because he has applied for under my lord's.
Is after 4 days, Mr.
Yes.
Counsel. 2nd July we are keeping.
Lord, say, otherwise, Lord, I will take out I will take out notice to the my lord the KE advocate and not also government advocate, my lordship permits.
Take out notice.
Yes, my lord.
Take
Kindly
up the notice.
tomorrow, my lord,
Permanent
kindly have it tomorrow, my lord.
Instead of we issuing, don't you yourself take out the notice.
My lord, say, my
We are
lord.
keeping on 2nd. If there is a difficulty in between, you file IA. What more we can do?
my lords, my request is, my lords, at least kindly have this matter tomorrow, my lords. Meantime, my lords, I will serve the KE advocate, my lord, as well as government advocate.
Such preferences can't be given. You serve the copy,
My lords,
you
in-
file IA if there is a need in between.
Not emergency, not that is, because any time, Lord, they may conduct the, Lord, the counseling,
All
Lord,
right,
they allot. the-
5th August.
Sorry,
Yet
Lord.
we are keeping it ahead of the schedule, our schedule. And we are seized with the matter. We can pass mandatory order. You can't dictate the terms.
Sorry.
Yes. First, keep it on Monday.
Much.
It will be open for the petitioner to supply a copy of the petition to
To the KE advocate, my lord,
learned advocate who normally
KE.
appears in this
And my lord,
copy of the Karnataka Education Board.
and respondent number 1 and 2, my lord, the government will take note.
Learned
I'll take
government
notice for
advocate.
R1, your
1 and
R1,
3.
Mamata Shetty.
1 and 3.
NK Ramesh for.
NK Ramesh for R2.
NK Ramesh for 8.
Except Sankaran. Second same.
Second, my lord, the 20, 55, yes, my lord,
Same.
locomotor.
So it appears that from second matter, it appears that you were undergone press medical examination.
My lord, in
and-
both the, my lords, in both the, my lords, in cases, my lords, I undergone second, my lords, medical examination. First examination show that, my lords, the 55% in second matter, but
Yes.
subsequently 20%.
So second examination was undergone before which doctors?
My lord, the same KA, my lord, authorities, they called the doctor in their premises, not examined them.
Which is
Karnataka Examination Authority.
0. First one.
we are keeping it on 28th,
Must,
Friday,
Yes.
Please, sir.
Much obliged.
both
In
matters.
Both the matter.
Yes.
The PL matters, seal number 5, Janardhan G.
The petitioner is the member of the 8th Respondent Society, my lord, and it has formed the layout and allotted one site. And my lord, he has been residing there. My lord, kindly see Annexure E, the civic community site has been provided for park and of that layout, benefit of the layout, but Annexure E, my lord, CA site, page 94.
Who will be the competent authority to examine?
But they have done it. But what they did was, kindly see my Annexure J.
They have done it.
Complaint was taken, but thereafter put it under the carpet from 2014 till today, they have not done anything. Investigation is.
They have already inspected.
Yes, but I have given a complaint, but kindly
No.
come to,
Complaint you have given, but they have inspected the place or not?
but they have called for report from second respond BDA about the same. What are the playout?
No,
layout,
we'll direct,
and the yes,
we'll direct and
Yes.
dispose of the matter.
yes.
Full stop. Heard learned,
Not
where is
last
your,
one.
where is your
Not Annexure J, my lord.
complaint, where is complaint?
Annexure J
Annexure A.
and the FIR.
And we dispose of the petition.
Yes, ma'am.
Yeah.
Annexure M is the FIR,
Annexure
page
M,
142.
Page 140,
Yes,
140.
142, my lord. 142 is the, not complaint is at reminder by the BDA is annexure.
Achha, FIR is lost.
Not
FIR is lost.
FIR is registered. Thereafter, it has been, nothing has been done. But investigation is also not progressed anything. But in spite of repeated requests, but the 8th, 4th respondent, 6th respondent
In
encroached.
addition to FIR, your own complaint is there or no?
My complaint is there.
Where is that?
But here, but it is on 2014. And on that basis, my complaint is dated 2011-2014, but is available in page
There is
133.
no action are taken again pursuant to FIR because it is not visible.
No, my lord, yes.
It is not readable.
I have it is,
How can they take action in respect of
what happened, Lord, after,
unreadable?
Lord, kindly see, Lord,
They
after,
are able to read nothing in this.
Lord, the addition, the fourth respondent has called upon the BDA to furnish detailed report and to investigate the matter further. But thereafter, it has been stopped from 12, 14, 15, Lord. That is the reason.
Present writ petition is filed. As public interest litigation. The grievance is about grievance of the petitioner who claims to be public spirited person, comma, is about civic amenity site at measuring 31986 square feet in survey number 111/1 of Pasri Guppe village, Bangalore. What is prayed is to direct the respondent authorities to initiate proceedings to recover 27586 square feet area out of 31986 square feet. Further prayed to demolish the constructed portion to the side extent of the land, which is put up by respondent 5 to 7. The petitioner has stated paragraph that he has filed several representations, including 21/6 several representations between the period 21/6/14 and 30th/4/19, but none have been attended to. The case of the petitioner as pleaded in the petition is inter alia that that the petitioner is a resident of the city of Bengaluru and member of the 8th Respondent Prana Pranja House Building Cooperative Society. It is the say of the petitioner that the land described as above has been reserved for civic amenity. And the purpose of the reserving the said land is for benefit of the members of the society. It is stated by the petitioner that the said amenity area has been encroached by private respondent 5 to 7 and construction is put up on the area of 27586 square feet. It is stated that an apartment is constructed utilizing the said common amenity area. The construction so put up by the private respondents, it is stated, has been annexed to the property, has been attached to the property of the respondents. Paragraph. It is contended that as such action, of the respondent 5 to 7, the members of the society are deprived of the common amenity site and the facilities available thereby. The petitioner has already filed the first information report, lodged first information report dated 24/6/14 in relation to the above alleged encroachment by the respondents. It is the case and the grievance that despite the above facts, the authorities have not moved themselves to pay heed to the grievance of the petitioner. Full stop. In the facts and circumstances case, it would be appropriate to dispose of the present petition by directing the competent authority of respondents to look into the allegations and the grievance of the petitioner, which are also lodged in form of the FIR, and to act upon the representations of the petitioner. Full stop. The competent authority of the respondents shall visit the site and after inspecting, ascertain as to whether the area is encroached to cover of the common facility site. If the encroachment is found, the necessary actions in law shall be taken. Paragraph. As far as the lodging of FIR is concerned, the police authority is concerned, should pursue the FIR by properly investigating the case and the allegations made in the FIR. Post law. This is the decision which may be arrived at by the respondents. Competent of the respondents shall be communicated to the petitioner within 4 weeks from today. So with the aforesaid direction, without expressing any opinion on the merits of the case of the petitioner, the present petition is disposed.
Serial number 6, the Dalwai Venkatesh.
Lots. One more matter, lots, where the interim order is granted. Connected to serial number 6, my lords, one more matter. The PA was on the subject matter of serial number 6 is same as the 110908/24. Same subject matter. So this has to be tagged along with
Shifting of veterinary hospital from Bangalore urban district.
the 110908 and the serial number 6, my lords, is land is same.
The notice to be heard with
Yes.
read petition number. This is coming up before which court? Different court?
My lord, before your lordships only. PIL only
One
before your
such-
lordships.
one
Date I am not aware which date it is.
This petition had come up before us.
My lord, this came up during
No, petitions
vacation,
are
my
not
lord.
common, your lordship.
Vacation.
Petitions are.
No, one such petitioner had come up before us also.
That is 10,586 of 24, the first one, serial number 6.
6 months. I appear in that serial number 6.
No, even other, one more
My
petition.
lord, those two are connected, my lord,
All right,
6.1
anyway.
and 6.2.
It was stated by learned counsels appearing for the parties that writ petition number 11908 of 24 contains the same subject.
Same subject.
In that view, there shall be notice in the present writ petition to be heard with writ petition number 11908 of 20.
Great.
Interim order,
Indulgence, permission, with the permission. Lordship has granted an interim order in previous coordinate bench.
Yeah.
No, not in that, 6.1 and 2, it's the main petition, where this honorable court has directed to the hospitals which remains there, it has to be functioned. In spite of the orders, except the hospitals are laying as it is, along with infrastructure. All the staffs have been shifted, and the hospitals are not functioning, and because of that, the existing citizens who are supposed to take the requisite treatment, they are affected. Those specific orders have been disputed.
I'll contend.
Your Lordship, since it is a public interest litigation,
May-
always your Lordship hands that.
interim order may be extension, my lord. In 6.1, I am appearing for petition, my lord. Interim order is there.
Which interim?
6.1.
and 2. There is an interim. It is there. Yes, I think your Lordship.
6.1 interim order.
6.1.
Interim order extension.
The interim relief earlier granted in the in the writ petitions number 758 of 24 and 614 of 24 shall continue. And it is directed that the services at the hospital shall continue, the doctors shall not be shifted, nor the staff shall be shifted. Till further orders.
Much obliged.
My lord, may I make one submission? My lord, the notification has been given effective before the filing of the petitions itself.
But if. this
No, I'm
comes,
just bringing it, my lord's name.
When it is replies are filed,
My lord, in the connected 6.1 and 6.2 statements have been filed. Now I have to file in.
when it is coming up.
My lord, it's posted today along with, in which my lord had.
The other-
11,908. Or a date was not given, your lordships may, after service of notice, your lordship,
All the petitions including 11,4908,
11,908 of 24.
7, whatever, including all the petitions, including we did petition number 11,908/24 will be posted on 23rd of July.
Obliged, my lord.
Much obliged.
The interim leave shall continue till 24th of July.
Very clear.
So that otherwise,
The needy people should not affect by virtue of not grant, providing the.
but the Miss Nilofer says
There are
that
23 hospitals which are lying as it is, along with infrastructure. The staffs have been moved to Solid. Very purpose of the existing, the hospital will not function, and the purpose for providing the requisite treatment will not.
so therefore you are enjoying relief. Why do you worry?
Obliged, my lord.
Obliged.
Number 7, Shyam Kumar SU.
Please, lordship. Lord, this petition has arisen out of a complaint from 25 of the inmates presently in the jail. That complaint is at page 64. They have complained on various grounds by which their, my lord, the parole, remission, furlough, temporary release, etc. are affected.
So what are the amendments in parole rules?
Sorry,
What are the amendment in the rules of parole?
my lord, what that is given at by amendment to under Rule 63, they produce Regulation 191. In that 91, they have given two substantial changes. One is when there is an appeal pending or when there is a bail application, then their parole, etc., will not be considered. So now the complaint is, my lord, whether should we ask for parole or should we file appeal?
Bail application is pending and parole is not granted.
Not considered. Under that, no.
Here parole and furlough both are,
Yes.
furlough is also given.
Yeah, all four are affected. Parole, remission, furlough, and temporary release. All four are affected.
Is there any rule that the parole or furlough is not granted when the bail is pending?
Yeah, that is the notification which I am challenging.
Notice returnable on.
My lord, I take.
This is not, this is. I think this must be only in state of Karnataka,
Yes.
this kind of notification.
Oh, that, my lord, that I'll have to verify. My lord, I take a notice for respondents, my lord. All the respondents.
On the contrary, when temporary bail comes up and the court is not inclined to, for one or other reason, grant the temporary bail, but the furlough or parole pending, application is pending,
Yes,
and it is given depending on the duration
yeah.
of
That's
the
right.
imprisonment. Then the competent
And
jail-
after good conduct,
jail authority
they earn
directed
it.
to consider that application. Where is the question of not grant? We'll say 23rd, 24th of July. Notice.
Obliged.
Which date? 24th. 22nd.
We'll take up this one, let us say little. When there is no bench. This can be taken, you assist the court.
Well, no,
Prima
that-
facie doesn't augur well, whatever, subject to what you have to say.
My lord, I'll seek instruction.
9th of July.
Yes,
9th of
sir.
July.
Yes.
9th of July.
Convenient. 12th or 13th of July.
13th is, nobody will come except you.
Oh, sorry. Because till 11th, I have case in Delhi.
15th?
Yes, much obliged. Much obliged.
Obliged.
Appearing for petitioner. I pray for the writ of mandamus, my lordship. Annex G. My lordship, I applied for a quarrying lease of to an extent of 3 acres, 16 guntas of building stone, my lordship. Only 2 acres has been granted and remaining extent is vacant, my lordship. And therefore, I sought for the grant of.
Where is your representation?
Annex G, my lordship.
76,
76.
page 76.
Yes, my lordship.
Annexure G.
Annex G. Three acres, 16 guntas, I sought, my lordship. Only 2 acres has been granted.
Only 2 acres granted.
2 acre has been granted. my
What was
lordship.
demanded?
3 acres, 16 guntas, my lordship.
So there is some rule now.
Lord, he applied for 3 acres, 16 guntas. The authorities, after considering his application, notified for grant of 2 acres only. At that point of time, he has executed an undertaking that he will not claim for the remaining extent.
Then
He is
Lordship,
very
if there
selective in disclosing the.
If there is, my lordship, if there is such undertaking, my lordship, I don't have any. Because, my lordship, it may be at the time of taking signature, my lordship, the authority, why he has not given 3 acres?
He should have
16
disclosed that in the petition. That is the primary thing he should have
I
done.
don't know, my lordship, that I
It
don't
amounts
have.
to suppression.
No, if you have given undertaking, they will not claim any further.
Yes.
Then
I'm sorry, my lord, it is in.
doesn't matter.
Serial number 1 is the
One is
petitioner.
No, you are saying that he has agreed not to claim.
Yes. The last Justice Arvind.
marking, while marking, this has been given, my lordship.
Given?
My party signature is there, my lordship. I cannot say it is.
So now you withdraw.
On this ground.
6 permission to withdraw the petition. Dismiss the bill.
This area.
So everywhere you are
My lordship.
very smart.
This is.
Number 9, Mr. Ganpati Bhatt.
This case, my lord, Annexure K, which is challenged, connected matter your lordship heard and posted on 9th. This is similar matter, that is WP 10180 of 2024. Lord, that is also connected. What is that?
The connected matter.
Yes.
You said your lord.
Yes. This is, my lord, government guarantee fact. Because, my lord, the stamp duty which they have claimed is on the basis of the NOC given by the Environmental Clearance Authority.
Petition number 10038 of 24.
For my land, they have claimed 1 crore and 13 lakhs. ಯಾವತ್ತು ಇದೆ? 9th ಅಲ್ಲ? That may be connected with this date.
Same date,
Please,
same date,
please.
10th of.
Much. 10. Much.
Number 10. Testify Shivali.
Lords, the petitioner had filed an application at annexure A, page number 16, seeking quarrying lease in respect of survey number 28/A part, an extent of 1 acre on 24/9/2012 for seeking extraction of ordinary building stone, not for which already NOCs have been issued. But in the year 2016, because of amendment, my application became ineligible. Subsequently, in the year 2023, my application became eligible for consideration. Therefore, I had made an application for consideration. So now they have issued me an endorsement at annexure F, page number 68, in which they say the present rule says the minimum required extent is 2 acres, whereas you applied for only 1 acre. That is the their
So how do you get out of?
but the applications filed in the year 2012, at that time only 20 guntas was enough. So I made an application for 1 acre.
4/10/2012.
But under the now the
News
recent
came into force on 17/3/23.
17/3/2023, under which they say minimum extent is required 2 acres. But my application was much earlier in the year 2012 itself. At that time, required extent was only 20 guntas. I had made application for 1 acre. Now, Lord,
Lord learned advocate, sorry, learned advocate, Mr.
Lord,
Valli Shiva
may I
Yogi.
make one submission? Lord, in any similar circumstances, the authority have already accepted and considered for execution of the lease. Similar circumstances. That too, the authority is joint director of additional director of Lord.
We are not the authority, we are court. What do you want?
So if that is the case, Lord, I am permitted to withdraw the petition
Learned advocate for petition response.
with liberty to approach the authority under revision.
The petition dismissed as withdrawn. Liberty is reserved for the petitioner to approach the authority. If they so advised, if the petitioner is so advised, this court, however, has not expressed any opinion on the merits of the case.
Much. Limitation.
Yes.
They have
Limitation.
no authority to
Pardon?
condone.
Limitation, because to file a revision,
If the remedy of revision is, it is observed that if the remedy of revision is resorted to is opted by the petitioner, the time spent in prosecuting this petition shall be treated as litigating bona fide.
much.
Writ appeal matter, CC number 11, Mr. Pundika Ishurabhat.
No, the
Appear
appeal
for
was
the appellant, my lord.
Okay.
In this case, what happened was, my lord, the disputed survey number 33/1A measuring 13 guntas of land was allotted.
This is the matter you mentioned.
Please, ma'am. 30, survey number 33/1A measuring 13 guntas of land was allotted in a partition dated 17/6/1964 as per annexure C, my lord. And they filed application for mutation in 2005, and mutation was effected in the name of the petitioners. And that was challenged by the respondent number 5 on the ground that her husband had purchased the property in 1968. That is their contention. And they filed application before the, filed appeal before the assistant commissioner, challenged the mutation order. And the learned assistant commissioner, before the assistant commissioner, we have produced this encumbrance certificate from 1964 till 2005. It would disclose, it does not disclose this sale deed. Therefore, he rejected the appeal. They filed appeal before the deputy commissioner. Even deputy commissioner has rightly held that because there is no entry. If they dispute or if there is a sale deed, they have to approach the civil court. Right decision was given by the learned deputy commissioner, even the assistant commissioner. That is a concurrent finding. And they filed writ petition where the learned single judge held that based on the sale deed should have been entered. I have to approach the civil court, not myself. They have to approach, my lord. When there is no entry in the encumbrance certificate with regard to the registered alleged sale deed, they have to approach the civil court for to establish their right that they purchase the land by virtue of the sale deed dated 1968. Kindly, I may take your lordship to the order passed by the assistant commissioner or deputy commissioner at annexure F, page number 100 and
This registered sale deed, registered partition deed was 17/6/16.
64, my lord. That is in our favor because in our family there was a partition and this property was allotted in our favor.
And registered sale deed is 23/12/68.
Please, that is their contention.
In favor, what is contention? It is there or not there?
That is their contention, my lord. They allege that that is
there or not? Registered sale deed is there or not?
no, it is not there. But
Not
they
there.
they
How?
my lord.
It is not there.
No, the reason is this: we have produced the encumbrance certificate even from the registrar from 64 up to 2005. That was produced before the deputy commissioner. He extracted the relevant portion. What are the documents we have produced before the deputy commissioner? Kindly see, my lord, order annexure, the order passed by the deputy commissioner annexure of page number 119, my lord.
So on the contrary, admittedly, there is a registered deed dated.
That is my lord, that is the finding of the learned single judge. Admitted, I have not admitted. I have never admitted that is there is sale deed.
It is a matter of fact whether the registered deed is there or not.
No, sale deed, it is our specific contention that it is not there. Therefore, what we did was, so far as that is,
My lord, it's produced as annexure A to the writ petition by the respondent number 4.
no, that is, they filed the document. That is disputed document because I have produced the encumbrance. My lord, my submission is that I have produced the encumbrance certificate. Kindly see the encumbrance certificate, my lord.
What is it? Must have been relegated to civil court. Declared, that's right.
Please, my lord. My lord, my submission is this, my lord. If there is a registered sale deed, of course, if it is there, it should be reflected in the encumbrance. Register office, that is maintained in the register office, they have issued the encumbrance certificate and I have produced the copy from 64 till 2005. It does not disclose this sale deed. Therefore, there is a dispute with regard to the existence of sale deed. Therefore, the learned deputy commissioner as well as assistant commissioner have held that because there is a dispute, they have to approach the civil court, not I, because they claim the right. It is seriously disputed and I have produced the registered certified copy of the encumbrance certificate secured from the registered office. Kindly see page number 119, the finding of the deputy commissioner. For a moment, my lord. May I read, my lord?
My lord, that apart, may I make one submission?
Lord learned advocate, Mr. What is your good name?
Pundika Ishwar Bhatt.
For the appellant and learned additional government advocate, Ms. Nilofer Akbar for the
Respondents 1 to 4.
and its authorities. It is at the instance of original respondent 5 that the present writ appeal is filed, present appeal is filed, wherein the challenge is thought to be addressed.
May I take your
Order dated 3rd June 2022.
May I take your lordship to the judgment of this honorable court on the point. That is 2005, Karnataka, ILR, and 6043. Revisional jurisdiction of the deputy commissioner under on facts held. Even if the matter warranted correction, the same will not resolve the dispute between the parties. Such matter even remanded on finding fault with such orders, it never attains finality and keeps on circulating. In such a situation, it is only proper determination by civil court in terms of the provisions of section 136(2) of the Act that can provide the finality to such disputes. Writ is dismissed. Accordingly, the learned single judge has dismissed the writ petition, holding that since there is a dispute, you approach the civil court. That is the
136 of this Karnataka calendar, 136, the paragraph. The sense, the crux of the dispute is the mutation of the name of the petitioner in the revenue records pursuant to registered sale deed dated 23/12/1968 in respect of the property in question. Writ petition was filed by the petitioner, original petitioner, Srimati Yellamma, response number 5 hearing, wherein the prayers were to set aside the order stated 16/12/11 passed by the revisional authority, as well as the order stated 28/9/2008 passed by the authority of the first instance in relation to land bearing survey number 33/1 capital A, head measuring 13 guthas, situated at Sora Hunase village, Varthur, Hobli, Bangalore East. The case of the petitioner was that the said survey number was inherited by him through his ancestor. Subsequently, husband of the petitioner, one Bajaya, Bajaiah Reddy, purchased the land bearing survey number 33/1 at measuring 13 guthas through a registered sale deed dated 23/12/68. It appears, as stated, Dispute number 5 thereafter filed an application before the Dispute number 4 authority for transfer of khata in its favor, claiming that there is a partition deed dated 17/6/1964. Also, the authorities appear to have accepted the case of the petitioner, notwithstanding the registered sale deed standing in favor of the petitioner. Learned single judge. Paragraph. Was eminently justified in observing that it was not open for the revenue authorities to ignore and disregard the registered document of sale deed dated 23/12/1968, standing in favor of the petitioner. Full stop. In paragraph 5 of the order, following pertinent observations and findings were recorded. In quote paragraph 5, page 15. Thus, admittedly, there was an registered sale deed. It was only in the encumbrance registered that the sale deed was not. Sale deed appears to have not been reflected. Full stop. Mere aspect of non-reference of register shall lead in the endorsement register would not wipe out the effectum of the register shall lead executed in favor of the petitioner. Full stop. Learned advocate for the petitioner. Relied in vain the decision of this court in Uttanaiha, UWTA, NAIAH, and others versus State of Karnataka. Into bracket ILR 2005, Karnataka 6043, which, on the contrary, stands against the petitioner's case in terms of principle laid down therein. Full stop. It is held that disputes of such nature are fit to be agitated and determined by the civil court in terms of provisions of section 136 into grade 2 of the Karnataka Land Revenue Act 1964. Full stop. Even if there is there is a section, which was that section? That 136 वाला निकालो. Full stop. Even if the petitioner, even if the riot responder 5 has, even if the appellant responder 5 has any grievance about the mutation and that he wants to assert his rights on the basis of the partition deed, the proper remedy for him would be to approach the civil court. Learned single judge has rightly stated that it is for the said respondent to obtain appropriate declaratory decree, and in which event the revenue authority shall abide by the decision of the civil court. First of all, a single judge was eminently was quite justified in allowing the petition. No error could be booked. The challenge in the present appeal is meritless. The appeal is dismissed with cost. No cost. What?
Seal number 12, to Nagarajappa A.
Lord, I am appearing for the appellant hearing. My lord, there is a delay of 131 days in filing the writ appeal, my lord. Lord, I have filed the affidavit, my lord, is at page 199, my lord. My lord, the reason for the delay of 131 days is, my lord, the appellant, my lord, is a lecturer, my lord. He has been retired on 30/6/2020, my lord. My lord, due to financial problem, my lord, and due to his ill health, my lord, he couldn't approach this honorable court, my lord, in time, my lord. The delay is not an intentional one, my lord. Lord, here, my lord, the appellant, my lord, is a lecturer, my lord. Is claiming, my lord, a retrospective promotion, my lord, with effect from 1998, my lord, as of the respondent number 3, my lord. His claim has been rejected, my lord, at Annexure S, my lord.
So when you were appointed?
My lord, as per Annexure A, my lord. I have been appointed in the year 1994, my lord.
Date?
Well, 17/3/1994, my lord.
17/3/94. 94.
94. My-
Then what was the period of probation? 1 year or 2 years?
2 years, my lord.
2 years, so
Please,
up
ma'am.
to 96.
Please, ma'am.
Now you did not pass the examination. Or
I
Kannada
have
Kannada
been passed, I have passed the examination, my lord.
In
Is that annexed?
99 you passed, 21/9/99 you passed.
1999, my lord, I have been passed the
So
examination.
as
my
per
lord.
the rules, up to 99, your probation could not be confirmed,
Please, my lord.
was not liable to be confirmed.
Please, my lord.
So after you passed the examination in 1999, when the probation was confirmed?
My lord, in the year 2000, my lord.
2001,
2000, my lord.
2000, 2000.
2000, my
Where
lord.
is the date? Nobody, it is not here.
Please,
No,
ma'am.
25/1/2000?
In the year 2000, my lord.
2000, all right. Now what is your grievance?
My lord, the respondent number 3, my lord, was junior to me, my lord. He has been considered and he has been promoted, my lord, in the year 1998 itself, my lord.
98?
98, my lord.
This one was 3, junior. So he must have been confirmed earlier than you.
Please, my lord, page
The
50,
seniority is counted from the date of entry or confirmation?
from the date of entry, my lord. My lord, this, my lord.
Where is the rule?
My lord, here, my lord, at Annexure B, my lord, the seniority list, my lord. The final
Annexure B,
seniority list of
Page,
page 52, my lord. Translated copy is at page 52.
who, anybody appears? Notice returnable. Where is it is not clear, Mister?
My lord,
We are
page
listening.
52, man.
Things are not that clear. Page
52, man.
52.
Annexure.
You are what, lecturer?
A lecturer, my lord. I have been appointed as a lecturer.
Want
Initially, my lord, I have been
Promotional post is
my lord, from assistant masters, my lord.
assistant
Master,
teacher,
my lord.
teacher.
Assistant teacher, my lord. Yes, ma'am.
So when number 3 passed the examination,
Please, my lord.
this one number 3 passed the examination, language
Lord.
examination in which year?
Lord, that information I am not aware, my lord.
That is that appears to be
but
crux of the.
the R3 has
Promotion is counted from which date?
for respondent number 3, my lord, it has been
Promotion, date of seniority is to be counted from which date? From the date of, again, same question, from the date of entry in the service or from the date of passing the examination?
from the date of entry, my lord, from the
Where is that? Where is that rule? Could you find out that rule?
Please, my lord, I will come.
When do you?
In the next week. Within
This
next week.
appears to be the crux of the matter.
Please, my lord.
And second thing, you have to find out when number 3 passed the exam.
Please.
2nd July will do?
Please, my lord.
2nd July to be listed at 2:30.
Yes.
In order to enable the learned counsel petitioner to take certain factual instructions before the petition could be proceeded further for hearing, from a standard to second to be listed at 2:30.
Please.
Number 13. Amresian.
Yes. Now, the petitioner before the trial, not a single judge, is a grantee under the PTCL Act. He was granted 2 acres of land at Jaknuri village. Plus, after several rounds of litigation, he has approached the Dissolved Court in an earlier round of litigation. The matter was remanded to the revenue authorities to look into the records, then take a decision. Thus, the revenue authorities, without looking into the relevant records, passed an order. That was again challenged before the second respondent's hearing, DC, Deputy Commissioner. And Deputy Commissioner again dismissed the rejected.
My lord, all those,
And therefore,
my lord,
That's
it may be called on third. My lord, these matters can be disposed of. I'll make my submission on the third, my lord, because
And it is, we fix a date and dispose of the matter.
yes, because the very act is not challenged before my lords, but the, my lord,
The delay part,
delay part, yes.
section 5.
Yes. And now with the act being challenged, my lord, since there is no limitation prescribed, they can go before the learned single judge and then they can agitate. I'll make my submission on the third.
That is valuable.
Third, my lord.
Third, yes, so give all the matter. Which is the lead matter? Any lead?
Writ appeal 210 of 23.
210 give. At least. No, third. On notice written on third,
Yes, I'm good.
to be listed with writ appeal number 210 of 210,
Third case.
23.
Other matters where delay.
Number 14.
I'm good.
Which one? 13 notice, issue notice, formal notice written.
Number 14.
My lord, 14, the earlier council has filed his memo for retirement, my lord. My lord, that may be accepted, and Mr. Aditya Singh, who is the present central government council, his name may be shown as appearing for petty appellants before my lords. My lord.
For appellant,
Please, for appellant, my lord.
name of learned counsel, Mr. So-and-so shall be
Aditya
indicated
Singh.
as appearing for the appellant while notifying the appeal on the next date, stand over to 23rd July. Earlier. Same council. First memo, additionally, memo dated, undated memo suggests that learned counsel, Mr. B. Sukanya Baliga has retired from service, has retired from the matter.
Number 15.
That's I picked up here, please, my lords.
Lord, similar matter may be called on the third, third, writ appeal.
5C, my lords, an amendment has brought into place by the
third.
legislation.
Third, my lord.
Legislation, my lords, 5C has brought into place. Now, it would say, please, my lords, it can be challenged. There is no limitation. It can be challenged before any court, any tribunal, any other platform, please, my lord. There is no limitation. It's for challenge. Now, the orders of the learned, the deputy commissioner and the assistant commissioner, they have shut me out only on the reason, please, my lord, there is delay and latches. The learned single judge also, my lords, throughout the petition, only on the fact, please, my lord, that there is a reasonable delay in having approached the writ court. Let's to file a writ, please, my lord, there might not be a limitation, please, my lord, is my respectful submission. And this matter could.
Obliged.
Notice written over on third.
Obliged.
Number 16, SB Mukkanappa.
Brilliant in this. I would turn next week, my lord. Week's time may be granted.
Week's time.
Weeks.
It will go to then 16th of July.
Number 17, Sarvana S. Nagraj.
This is the writ appeal, my lords, where my lords pronouncement of judgment. Cooperative society.
Is it cooperative society?
Please, my lords.
But you file your schedule with
I
what?
will,
right?
we have filed a schedule already.
Along with what? I could not find. it.
My lords, on 28/5/24, there is a memo, my lords.
Nobody is there.
Sarvana S.
Will pass order in his presence.
I will place another copy, my lords, if it,
No, order will be passed in his presence.
please. Please.
Nowhere in the earlier order it was recorded that due to Lok Sabha elections, you are wanting to.
My lords, sorry.
In any of the earlier orders,
Please.
was it recorded that because of Lok Sabha elections, parliamentary elections, you could not held the?
It was not actually heard, my lords. The matter was not heard. Please.
Also, number 18.
Here for the complaint, my lord. The respondent is my mother. She is the daughter of a retired judicial officer who is no more. She is also a coffee planter. The beneficial provisions of Senior Citizens Act has been abused, not by my mother. It is a sibling rivalry. And now the learned single judge has ordered for paying maintenance of 7 lakhs. And he has also put a condition, my unconditional sale deed. It did not contain any conditions. Now the learned single judge says that it has made it a condition gift deed. Therefore, I am before your lordship. The deputy commissioner who has set aside the order of the assistant commissioner, maintenance tribunal, kindly turn to page 60, my lord. May I request your lordship to turn to page 60. At paragraph 60, page 60, that is the order passed by the deputy commissioner. In paragraph 28, your lordship may kindly see. Great respects to the learned single judge. Spirits from grave has also entered into this agreement. Learned single judge in paragraph 3 has recorded a finding that a dead person has obtained a judgment and decree, and he walks away with 24 acres of land belonging to my mother. It is factually incorrect. And OS is still pending.
What is the problem?
My lord,
What is the problem? You are fighting with your mother.
it is sibling, my younger brother is staying with my mother. He is unemployed. He is assisting my mother with a coffee estate of 24 acres. 24 acres. He is the root cause for this. Because he is operating the bank accounts, he is withdrawing the amount. I have kindly turned to page 125 of my statement of objections filed before the learned singer. He has not looked into any of these documents.
Show the-
125, my lord.
What was your challenge before the?
Deputy Commissioner.
Oh,
Deputy Commissioner, I challenge the order of the Assistant Commissioner, Maintenance Tribunal.
where is that order?
It starts from page 50, Annexure A is the order passed by the appellate tribunal.
Page 50. What is that order?
Pardon, my lord?
What is the order?
The order passed by the appellate authority, that is the Deputy Commissioner Madikeri, is against the order passed by the appellate tribunal, wherein my gift deeds were cancelled.
Which is the first order in point of time?
Pardon me?
Very first order in point of time.
Point of time was the order passed by the Maintenance Tribunal at Madikeri.
Maintenance Commissioner.
Maintenance Tribunal,
Right, where is
headed
that?
by Assistant Commissioner
Where is
Madikeri
that-
Subdivision.
Where is that order?
Page
It is
17.
page, it is at Annexure B, page 63, my lord.
63.
Yes, ma'am. Translated copy commences from
Page
70 onwards, my lord.
So that application was filed by whom?
My mother.
Mother.
This application was filed contrary to the, by suppressing material facts which are contrary to the rules framed by the state government.
Then what happened?
Pardon me, my lord?
Then this order was challenged by
This
you?
order was challenged before this single judge of this court.
By you?
My lord?
By you?
By me
Not-
and the fourth respondent.
Not before the appellate tribunal.
No. Learned single judge said that there is an appeal provision under the Senior Citizens Act, kindly go before the appellate tribunal. Therefore, the appeal was filed before the deputy commissioner.
So therefore,
Deputy commissioner entertained the appeal,
that is, which is page 50?
which is page 50, my lord, Annexure A. By a detailed order, after analyzing the provisions of the act and also noticing at page 60, paragraph 28, your lordship may kindly see. Page 60, paragraph 28 of the order passed by the appellate authority. It is
Appeal was
further, may I read, my lord? It is further observed that the respondent, that is my mother, had the transaction of rupees 1.57 crore in 3 to 4 years and rupees 75 lakhs from other sources, which proves that she is doing well and no issue of unable to maintain herself as alleged in the objection statement. That means my mother is financially sound. Apart from that, since we are residing at Bangalore, we could not physically manage the estate, whatever has been gifted to us. The entrustment was given to our younger brother, and we used to send money to our mother's account for the maintenance of the estate. It is not 48 lakh rupees as the Leonard Singhal has made out. The transaction was 71 lakhs, including the use of fructus generated from the estate.
What did Learned Single Judge do?
Pardon me?
Learned
Leonard Singhal judge has upheld the order of the deputy commissioner. He has upheld the order of the passed by the deputy commissioner, but he has modified it, putting a condition that since there is a bank statement showing that you have paid 48 lakh rupees to your mother, since the amount is not mentioned, it is silent in the order of the appellate authority. You pay, you are subject, you can enjoy the property subject to a condition that you have to pay 7 lakhs per annum to your mother.
he has put a condition which is not there even in the gift deeds also.
So what is wrong in this order?
Pardon me, my lord.
What
No,
is
lordship,
wrong
may I kindly turn to page 125 for a moment. Page 125.
You are for mother.
I'm for the respondent number one, mother, my lord.
Kindly turn to page 125.
So what happened to that coffee plantation?
My lord, the part of the coffee plantation she still retains, my lord. 24 acres is with the mother.
Retaining 24.
Yes, and the remaining about 11 acres has been given to the appellant, my lord, and remaining one more 11 acres has been gifted to the granddaughter.
No, for a minute, may I request your lordship to see page 125. This is the application.
Now the gift deeds are in respect of what?
The gift deed under challenge in this WP, my lord, is in respect of 11 acres, my lord. This WA is 11
The
acres.
plantation,
It's a plantation. It's a coffee estate, a plantation.
11 acres.
Lordship,
It is given to you.
Given to me,
give
no.
it to my son, my lord. I have gifted the property to my son, the appellant here.
11 acres
11 acres of coffee estate.
out of,
48
For
acres.
48 acres which I held, I have given 11 acres
so
to
48 acres belong to you
belong to me,
and 11 acres given to son.
given to the son.
One son and one granddaughter.
Just given for some maintenance.
It was given under a gift deed, my lord.
So what is wrong in this?
My lord, a gift deed does not, your lordship are very well aware. My lord,
What are you doing in life?
I was working as a manager for some other coffee estate. Now I am no more in that estate. I am retired person now.
Why were you fighting with mother?
No, I have no such intention to fight with my mother.
Your intention to fight with him?
No, my lord, it is a rivalry sibling. That's the reason I am requesting my lordship to.
Nobody fights with the mother in entire universe. You know that?
Yes, I respect my mother. It is not fight with the provisions of the act has been abused by my sibling.
In entire universe, nobody fights with the mother.
It is not the question of mother. I respect my mother. I respect my mother. Kindly for a moment.
We don't entertain such a dishonest litigant.
No, it is not the question of dishonesty, my lord.
No.
Your lordship, the gift deeds are unconditional. Your lordship may kindly see your own judgment. Your lordship have passed. It is not the question.
Apart from all these things, this order is absolutely perfect of law on a single judge.
I will bow down to my lordship. Kindly modify the order. Let there not be any condition put by the learned single. What is the power for the learned single just to convert a condition, unconditional gift deed into a conditional gift deed? It is not the question of payment of money. Your lordship may kindly see the operative portion of the order. At paragraph 2, order of the deputy commissioner which directs payment of maintenance, the petition is also sustained with a modification that respondent 1 and 2 donees would be entitled to enjoy the fruits of gift deeds executed by the petitioner subject to the condition that they would pay maintenance. Let this condition be modified. Let there not be any condition. And why my mother has gifted this? She is on judicial record. Your lordship may kindly appreciate it. She is not a person who are in need of any basic necessities.
My lord, I appear for respondents 3 and 4.
For a moment.
Respondent number 2. My lord, respondent number 2 has to be represented, my lord.
My lord, it is not the question of
Sorry, I appear for respondents 2 and 3. Respondent number 4 has to be represented.
May I request your lordship to see why these gift deeds were executed by my mother? She is on judicial record. My mother is on judicial record.
What is the direction?
May I request the indulgence of your lordship to page 309, please. May I request your lordship to turn to page 309? 309, my lord. Why my mother has executed a gift deed? The reasons have been assigned. She is on papers before the judicial forum. She had filed this OS 195 of 2016 on the file of senior civil judge at Virajpet, seeking rendition of accounts in respect of the 48 acres of land, her estate, maintained by her another son, A.B. Biddappa. That is annexure R10. It starts from page 300. Kindly come to paragraph 22. Paragraph 22, my lord, it is at page 309. So it is submitted that plaintiff, that is my mother, who is a senior citizen and in the evening of life, is greatly perturbed at the turn of events, decided to settle all the matters during her lifetime itself, as she has lost confidence in the ability of her children to settle the property matters in a fair and just manner, and accordingly, that is true. My only submission. No, this is a plaint government. Filed by my mother, my lord. Mother, at annexure R 300, your lordship will get it. It starts from 300. No, why? The reasons why my mother has executed these gift deeds. It does not contain any relating to maintain, whether there is a gift deed or no gift deed. It is our pious obligation to maintain our mother. There is no dispute about it. Not the question of gift deed. My only respectful submission to your lordship is, we are not saying that we will not pay maintenance, even though she may be having a luxurious life. That is not our intention. Now kindly see our bona fides even before the deputy commissioner. Kindly see, I have to page 60. pays even before the deputy commissioner, we never said, although we have challenged the order of the maintenance tribunal, kindly turn to page 60 at paragraph 30 of the order of the deputy commissioner. Paragraph 30. It is further noted that there is a clear admission from the appellants, that is myself and my niece, that they are ready to pay rupees 4 lakhs per year till the lifetime of the respondent on going through the said development. It cannot be said that appellants have modified intention against the respondent in connection to the fact of providing basic communities physical needs. Notwithstanding the fact that my mother is a coffee planter, having crores of rupees, still before the deputy commissioner, we said she has executed the gift deed, we are ready to pay. We never said that we will not pay. Now our only difficulty is, it cannot be rob Peter to pay Paul. My younger brother, he is utilizing this money from my mother's account. Kindly turn to page 125 minute again. He is withdrawing the money. So therefore, my respectful submission is, insofar as the condition imposed by the learned single judge, with my great respectful submission is, he has no judicial power to convert an unconditional gift deed into a conditional gift deed, is my respectful submission. It runs contrary to the provisions of the Act itself. The jurisdiction of the maintenance tribunal arises if twin conditions are there in the gift deed. Otherwise, maintenance tribunal itself has no jurisdiction. When the maintenance tribunal has no jurisdiction, passing this kind of order asking me to pay 7 lakhs per annum and making it a condition for enjoyment of the property is not legally sustainable, is my respectful submission, that's all.
Yes, my lord, in 2016, the gift deed was executed, my lord. And there was no written condition in the gift deed that they would pay me any sum. However, there was an oral condition that a sum of rupees 14 lakhs would be paid to me. And that condition, my lord, was acted upon. Between 2016, 17, 18, 19, they pay me 14 lakhs per annum. However, they stopped the payment by end of 2019-20. That is when I have approached the AC seeking cancellation of the gift deed. The AC cancelled the gift deed, my lord, which was challenged before the DC. The DC, my lord, has, while setting aside the order of the AC, has directed that they should provide me amenities and also pay me maintenance. That part of the order they do not challenge. They are not aggrieved by that. When their appeal is allowed, that has, that has been extracted in the impugned order, my lord, on page 26. Page 26 only, your lordship can take 26, my lord. The learned single judge has extracted that portion of the order on page 26, my lord. Same. So what the learned single judge has held is that the DC has directed them to provide amenities and physical needs along with maintenance amount, which is being paid annually to be paid without fail till the lifetime of respondent number 1. So that oral condition was acted upon at an undisputed point of time. They were paying me 7 lakhs. So when the DC has said that they have to pay me, it has not been quantified, which is what the learned single judge has stated in para 11, my lord. On the next page, on page 27, para 11 is the observation of the learned single judge regarding that. What is germane to be noticed is that the respondents 1 and 2 have accepted the order of the deputy commissioner. The deputy commissioner nowhere says that maintenance will have to be paid in terms of the act. The order of the deputy commissioner is maintenance which is being paid annually to be paid without fail till the lifetime of the petitioner as accepted by respondents 1 and 2. What is being paid by respondents 1 and 2 is a sum of rupees 14 lakhs every year, 7 lakhs each annually. This is evident from the bank statements between 2016 and 19 and that is admitted by the learned counsel for respondents 1 and 2 that respondents 1 and 2 did transfer rupees 48 lakhs. Therefore, respondents now 1 and 2 now cannot contend that they would not pay the maintenance to the petitioner till her lifetime. So all that the learned single judge has said is there was that oral condition which was acted upon. The gift deed has not been set aside, my lord. They continue to be the owners of the property. While they're taking my property, they said, just pay me the maintenance. Yes, my lord. The gift deed which I have executed in their favor, that has not been set aside. All that the learned single judge. Yes, that remains, my lord. So they want to take my property and still not pay me. They're saying 4 lakhs to 10,000 is all the peanuts amount they're offering me, my lord, while my coffee estate earns lakhs of rupees per year, per annum. They're having the benefit of my coffee estate, which earns lakhs of rupees as income. All that they have to pay me is half the income from the estate, my lord. That also they do not want.
My lord, no, I have not denied paying anything to my mother. Even before the appellate authority, there was no cause of action at all. All these provisions, noble provisions of the act has been abused by my younger brother, with whom I have got enmity, and he has used my mother's name for the purpose of this litigation. And I did transfer. How the transfer has taken place, I have explained at page 125. May I request for a page 125? That is annexure R2. This is the application I have filed. I am an affidavit before the Deputy Commissioner. Kindly turn to page 128, my lord. 128. I have in tabular column, I have given total amount transferred to first respondent, 71,27,000 because of the towards the maintenance of the estate, and also the amount derived from the usufructus of the estate. Total estate expenses paid, 16 lakhs, that is from my mother. Amount returned to the appellants, that is, my mother has returned this amount to us. I am 128, 128. 71,27,000 to her account. Total estate expenses paid is 16 lakhs. That is because we are residents of Bangalore. The expenses towards the maintenance of 24 acres per annum, through bank transfers to my mother's account, in favor of my mother's account. And amount returned to the appellants. My mother has returned 7,19,000 to us, myself and my niece. She herself has transferred this amount, my mother. The remaining amount was 48 lakh rupees. And she did say that I want to retain this amount for my welfare. We said, no, okay. We have no objection. This, the learned single judge says, this is the maintenance amount. Lordship can kindly appreciate. There is no doubt we are under obligation to look after aged parents. It is our bounden duty, whether this gift deed exists or do not exist. That is a different issue. It is a pious obligation on all children. We accept it. We did transfer this amount. My mother wanted to retain 48 lakh rupees. We said, okay, please. Because she never enjoyed the property all those years, because it was looked after by my other brother, against whom she had filed a suit for rendition of accounts. Now that after executing these gift deeds, even after retaining this 48 lakh rupees, now they say it is a maintenance amount. You have not paid that, you have not paid this, and they have dragged it to the litigation. Now, I am not blaming my mother. She is 85 years. She never had any kind of tiff all these years. Now, at this age of my life, I am also a senior citizen. Now, my younger brother, who did his master's in English in UK, he comes back, who has no property. He is assisting my mother with 24 acres. And he said he is the root cause for all this litigation. That is the reason, my lord, nothing else. Yes, madam.
Where?
Day after, much of it. I'll be one more request, my lord.
Rupa Roon. Rupa Roon. Roon. R-O-N. R-O-N. Roon.
Your lordships, kindly may I make one submission, my lord. I will be satisfied if the learned single judge's order is modified by removing this condition. Whatever we are going to agree to pay, we will pay. We have no difficulties at all. Whether we have money or not, whether we are living in penury or not, that is a different issue. It is our mother. We are ready to pay.
One. R1.
My lord, I appear for respondents 2 and 3. My lord, respondent number 4 was represented by the appellant before the learned single judge.
They have filed a different writ appeal, my lord. Respondent number 1 has filed a different writ appeal.
Because at the time of filing of the appeal, if this writ appeal is day after tomorrow will be. we are banking upon my lord's judgment regarding the interpretation of Senior Citizens Act, section 23. More specifically, my lord has had an occasion to interpret the provisions of section 23 of the Senior Citizens Act. And when my lord has clearly stated that unless these two twin conditions are there in the gift deed, maintenance tribunal will not get any jurisdiction.
Yes.
Yes, ma'am. Day after tomorrow.
Day after.
Day after. Yes, ma'am. Please, please. ma'am.
Great.
Please, ma'am. Please.
This is number 19. HL Pradeep Kumar.
My lord, I'm sorry, in the earlier matter, the learned Singh, there is one glaring factual mistake the learned single judge has done. That is in paragraph 3. Your lordship may kindly see. That is the reason I made a mention that spirits from grave has entered. Kindly turn to paragraph 3 of the statement. That is a very glaring mistake the learned single judge has made. Of course, it may be unintentional. With great respect. Paragraph 3, your lordship may kindly. Petitioner is a widow, aged about 85 years, resident of Herur Estate, Siddhapura, Virajpet, Taluk, Kudugu district. The petitioner owned 48 acres of coffee plantation and was residing in the ancestral house of her husband. The petitioner has 4 sons. The first respondent is the third son, and second respondent is the daughter of the first son, who is no more. That is a factual aspect. First son is no more. Correct. First son, that is my elder brother, is no more. It is a correct fact. In respect of 48 acres of coffee plantation, the petitioner, eldest son, that is my eldest son, that is the first son, instituted a suit. That is wrong. Instituted a suit in OS 174 of 2 for specific performance to execute a sale deed of 24 acres, which comes to be decreed. No, it is not correct. It is still pending for consideration. That person has not instituted any suit. And accordingly, he takes possession 24 acres of land. What remained was 24 acres. That is factually. 24 acres remained with my mother. But the dead man has not walked away with 24 acres. That is a factual.
This is number 19. Mr. HL Pradeep Kumar.
Lord, notices us to go on, my lord, delay application, my lord. There are connected matters pending adjudication before this court, my lord. Maybe tagged along.
Pradeep.
Lord, connect similar matters are pending before this court, my lord. Following, my lord, a judgment. My lord, the acquisition proceedings initiated and the KD Act, my lord, was quashed. My lord, the similar matter is pending adjudication, my lord. It may be tagged, this case may be tagged along with, my lord, the. Obliged.
This is number 20. Mr. Satish K.
But I'm appearing for appellant, my lord. Against the very same impugned order, the state government has preferred writ appeal, my lord. That is pending. Both matter may be tagged, my lord. Writ appeal 776 of 24. 776 of 2024. Statement.
Obliged. Number 21. Som Sundar Rao.
Lord's appellant is one delay for 25 days. Yes. No, suppression, it is the producing, the allegation is producing a transfer certificate at the time of joining the school, job. But I laid the evidence before the labor court, certain documents are marked.
Those documents are marked, but learned single judge and labor court did not appreciating. Therefore, Lordship may kindly, I establish on judgment on there is a specific in Supreme Court says in Ramu versus KSRTC, those discrimination, I have produced all those documents before the labor court. Certain documents are marked, but labor court did not appreciating. Therefore, I filed a writ petition. Writ petition also the learned single is not appreciating those documents. There is a specific Supreme Court says the discrimination is there that allowed the petitions. On notice will be ordered. Now let the merit also. On because one for disposal, because once it is main petition also goes, I will dispose of. And then later on, when after notice received, though both main and delay. Okay. Both as well as.
Number 22. Hey, Praveen Kumar Hiremat.
This matter relates to, my lords, minimum wages notification, my lords. Minimum wages notification, my lords, which was set aside by the learner single judge, my lords, and 5th of July, my lords. Much of.
5th of July. Number 23.
I'm for the petitioners in this case, my lord. And in this case, my lord, as a PAL filed, that my lord, license was granted in a particular river in survey number, my lord, but the respondent 8 is who is extracting the sand from the adjacent Gomala land, my lord.
I'm for the respondent number 8, my lord.
That, my lord, there is a vented dam, 2 vented dams, my lord. Upstream, 250 meters, 1 vented dam is there, my lord. In downstream, 2 kilometers, 1 vented dam is there, my lord. In between waters, to be used for the drinking waters for the villages, my lord. That, my lord, in that intent letter, my lord, that annexure B issued by the Deputy Commissioner, that for the survey number 51, for the acre 1.50, my lord, that is in page number 61, translated copy that, my lord. That gazette notification published for the survey number 51, 1 acre, 50 acre, my lord. That, my lord, subsequently, that respond number 4 modified that survey number was mistaken, and that the survey number may be read as 181, my lord. That 181, my lord, a sketch I have produced in page number 85. That next annexure C is that, my lord, that is the page number 67. It was mentioned that survey number 51 mentioned in reference notification, state letter, reference intent letter in should be read as section, sorry. Actually 51, that gazette notification issued for the survey number 51, my lord. That
Respondent number 8.
Respondent number 8.
But my lord, there was only mistake is that with the survey number, my lord. And my lord, in this case, my lord,
that my lord,
who appeared before this court is not in a clear hand, my lord, who is the illegal sand extractor, my lord. Petitioner number 2, who is the illegal sand extractor, my lord, where I produced a document in which it clearly shows that he is
the same was not served to me, my lord.
Yes, my lord.
Name.
That, my lord, Karnataka Rural Infrastructure Development Limited. That's a
in previous day, I have produced a document, my
and
lord.
to be used for the purpose of
document. It is clearly shows that
I will get an instruction from
petitioner
these
number 2,
documents.
who is extracting the sand illegally, my lord, where he has made a declaration that vehicle number K20A3733, which belongs to him, my lord. In page number 7, signature which is styling, my lord, with the affidavit.
May I make submission? Not this, in this petition styled as PIL, there's no public interest involved for this reason. Lord, the petitioner number 1, who made a representation to the authorities initially.
The annexed
That-
H, my lord, the villagers also made a representation, my lord.
Only one representation is by the villagers.
No,
and
surveyor's representation, I have produced one of that, my lord. Sorry, my lord. Sorry.
all the representation, but for one, has been submitted by the petitioner number 1. That has been answered by the competent authority at annexure J. Page number 89 is the Kannada version. English, I don't know whether it is. Page 110. 110. Page 110 is my annexure J, dated 18/1/2024. This is not under challenge. Page 90. Representation has been answered in page number
110.
110, because in my representation that has been answered. I don't know, 90, 110 is the endorsement issued by the senior geologist dated 18/1/2024. English translation. KRDIL is a government undertaking. This lease has been granted in favor of KRDIL. This is one aspect of the matter. So far as second petitioner is concerned, he has been doing illegal extraction of sand. And in several occasions, he has been fined. Penalty has been imposed. Those documents are produced by respondent number 8 along with their statement, my lord, which is also on record. Chowdhury.
That's respondent number 7. They've given us a representation which we can't even consider.
Pratik R. Shetty. R. Shetty. Pratik R. Shetty. 8 months.
No, my lord. Respondent number 8 is a government of, yes, ma'am.
One one four is the photographs I have produced. There. That Gomala land, my lord, that farmer, the Dibba. No, just, please. Sorry. Please.
No interference will be tolerated. Yes.
Yes. Now, may I make one submission? No? Before granting sand mining, there is a provision under 31R in the present act. There is a committee called Sand Monitoring, District Sand Monitoring Committee. Consists District Sand Monitoring Committee as per 31R. It consists of Deputy Commissioner, Assistant Commissioner, and DCF from the Forest Department and various officials. Yes, Mlad, they have conducted everything. Initially, they'll inspect about the sand deposits in the particular area, conduct survey, thereafter prepare. Please. District Sand Monitoring Committee. Monitoring Committee.
Complaints in contempt matters, seal number 24, Mr. Manjunath Rao.
I am for the complaint, my lord. I am for the complaint, my lord. Complaint affidavit is not furnished to me, my lord.
That's,
What
writ
is the
appeal has
affidavit?
been preferred against the learned single judge's order, my lords. Writ appeal number 633 of 24 may be tagged along. Lords, we have filed it, my lords. Date has not been. Please.
Seal number 25. Amy Sundar Rama.
I am for the pleading applicant, my lords.
Respondent numbers 1 to 2.
I have not got.
I seek 1 week time for,
What impleading?
This PIL is a very old PIL, my lord, involving a layout called the judicial offices layout. This. No, my lord. Offices House Building Cooperative Society. Land was acquired by the government. The allegations, my lord, are relating to there are various allegations, my lord, with respect to mismanagement of the acquired land of the government, and thereafter allotting it to persons. Yes, but it's a society meant to be of judicial officers and of the staff. District and High Court as well. High Court as well. As a matter of fact, this, including High Court judges as well, and Supreme Court judge.
If they say that honorable High Court judges can be members, my lords, then they won't have a case at all, because they will be considered as associate members. Their entire grievance. may
This,
also
my
be-
learned friend may not
This
jump the
one-
gun, my lord, right?
Another coordinate bench of this honorable court, my lords, has held that they cannot be members because they are not judicial officers.
This, I must point out to you, lordship, what all has happened in this case, because it's been pending from 2007. The division bench, special bench had been constituted to hear this matter. After many years, my lord, an order was passed holding, my lord, that various allotments which were made were illegal, because it was not only made to members who are so-called members, but also to persons unconnected with the judiciary. And therefore, my lord, a lot of allotments were held to be illegal. However, my lord, that order was thereafter reviewed by the division bench again, and the writ petition was directed to be reheard. Then, of course, COVID intervened and all of those. And then, my lord, this honorable court directed the registrar of cooperative societies to carry out a suo motu investigation and to file a report before this honorable court. Now, a report has been filed before this honorable court with, my lord, the entire investigation papers, I'm told. We, of course, my lord, we received a copy of the report. which is entirely in Kannada. I don't know if my lord, the government has filed a report, a translated copy in English for your lordships to examine as to what is there. Because the order was not to examine thereafter as to whether the writ petition is maintainable, should it be continued or not. And therefore, this report became relevant. That is where it is at present. And therefore, if the government is not willing to translate, I'll have to translate it, not for your lordships to examine what is contained in the report. Because I understand some of them, they found some of the allegations to be true, some of the allegations not so true.
File a translated report, my lord. We have placed the report on record. However, translation is not produced.
That's it. My submission, my lords, this honorable court will not look into, my lords, all those aspects. An inquiry has been held by the registrar. It was a complaint all through by the writ petitioners, my lords, that there is no inquiry that is being held. This is not the first time, third time an inquiry has been held under everything, my lords, allotment and Section 64 of the Cooperative Societies Act, my lords, provides for an inquiry to be held. Thereafter, my lords, the act is a complete code in itself. There is an order that has to be passed under Section 68. My lords, this honorable court will not, my lords, sit as a supervisory body to look into whether the registrar, my lords, their allegations was that the registrar is not conducting any inquiry as to the irregularities and the illegalities of the society. That's why, my lords, this honorable court on 12/9/2019 called upon the registrar whether he will suo motu conduct an inquiry or not. The registrar, my lords, has conducted an inquiry. My submission, my lords, this is not the first time an inquiry is being conducted in respect of the society. This is the third inquiry, 64 inquiry, third inquiry. Two of them have already resulted in an order under Section 68, my lords. Again, 68 order, there has to be notices has to be issued. If your lordships would look into Section 68, my lords, notices will be issued, and then the society will be called upon to comply with the directions, my lords. And until the complete compliance is done, the registrar will be calling upon the society. But still then, our humble submission, my lords, even from beginning, we are saying a writ against a cooperative society is not maintainable. 226, my lords, would there is an efficacious alternate remedy. They kept complaining that I'm for the society, the respondent society 1 and 2.
I'm for the petitioners, my lord. It's a PIL. It's a PIL formed by certain filed, my lord, by certain former judges of the court. They are all members, my lord. They are former judges of this court. Lord, I beg your pardon, my lord. Lord, they were filed by former judges of this court and other members who pointed out, my lord, grave and serious irregularities, which ultimately met with acceptance by this honorable court. Which was met with acceptance by this honorable court, and this honorable court actually allowed the writ petition. It was subsequently reviewed. And after which, my lord, an order was passed asking if the registrar wants to conduct an inquiry or not, to submit the report to this honorable court for this honorable court to examine it and then consider the writ petition. It was not as if, my lord, direction was issued saying the writ petition need not survive and the
Yes, there is entire machinery.
there is a machinery. No, yes.
Section 68 may kindly be looked into.
No,
my lords,
but
by
what,
my lordships.
if your lordships look at the order that was passed in this case, it was not, my lord, to say that your lordships would give up jurisdiction in the sense that now it will go to the hands of the cooperative society registrar, who will then take over this entire issue. Plots are allotted, there are houses, my lord, there are various people who are living there, all of that has happened. But the question now, my lord, is who takes responsibility for what has been done with acquired land?
My lords, there. Yes. Admittedly, my lords, all
That
those
is-
petitioners.
It was the case, my lord, right from 2007. This is the case, my lord, which has been said over and over again. It is not as if, my lord, my learned friend is suddenly saying something new for the first time. They did.
No.
No, one second. To me, kindly grant me a minute.
I'm sorry.
Thank you. Therefore, my lord, this whole issue, my lord, then went right up to Supreme Court. Supreme Court then said, consider the question of whether it is maintainable or not, and sent the matter back. And they've gone several times to Supreme Court to say, please consider issue of maintainability. There is a report. Your lordship must look at the report, because ultimately your lordship, of course, if your lord ultimately feels after looking at the allegations that are there, we, my lord, have said that there is a need for a CBI investigation insofar as the issues are concerned. And that is our prayer before the honorable court.
with respect to, my lord, according to us, land which was acquired for a particular purpose. The purpose has been completely defeated, not with respect to members of the judiciary, but with respect to people who are unconnected with the judiciary, being allotted sites and given sites, my lord, at throwaway prices is what they claim. And why would they give it when there was such a large number of officers of the judiciary waiting to get a site, and you are giving it away to other members of the bureaucracy, people who are unconnected to anything to do with the judiciary? That was a larger issue. It's very, my learned friend is not, in my humble submission, making short shrift of the entire issue. The issue is with respect to why did you do and allot lands to people unconnected, which is why, my lord, I beg your pardon, my lord, the lands were allotted, sites were formed and allotted to people unconnected to the judiciary. Unconnected, because land was acquired for a particular purpose. And the purpose was to allot it to members of the judiciary. Huge allotments are made and lands, my lord, are completely given up. Beg your pardon, my lord? They were made, my lord. They were called associate members and made. Associate members, but membership required. There is eligibility violated. Prescribed eligibility is bylaws specifically prescribe the eligibility. All those eligibility conditions are violated. Sites were allotted to third parties, unconnected to the judiciary. We said wherever it is given to a judicial department or a member of the judiciary can't have a complaint. But the larger question is, how did you give it to others? And they called them associate members, nominal members, and sites were allotted to them. When people in the judiciary were waiting, Lord, there is a list which we had prepared, which we could gain. Then, Lord, they have filed, as a matter of fact, an entire list. Lord, society is formed in 84. 83, 84.
1993.
The member list is there. They have filed the member list before this honorable court. It's in a sealed cover.
My lords, in the year 1993, the government passed an order.
Some sites are empty. Some sites are vacant. Some they've sold. Of course, now, of course, whether we can undo all of that, I don't know. Lord, but then the question, Lord, is now to find out who is responsible for the state of affairs. Lord, I would respectfully say point of no return can occur in many scenarios of this kind. Lord, what I want your lordships to consider doing ultimately is to see if some corrective steps can be. Yes.
Yes.
It's really, my lord, they have no vested interest in all of this. And it's not that they will gain anything.
Please, ma'am.
Yes.
Nine.
This will take, it took about 10, 12 years to be disposed of in the first stage.
1993 itself, my lords, government passes an order directing all the cooperative societies to.
We've made a synopsis, my lord, a synopsis. As a matter of fact, every allegation we've made has met with admission by the society in the statement of objections. Every single allegation I've made has been met with objection. Yes, it's a short synopsis, not already on record. We'll try and do one thing. We'll try to ensure that the papers are in order.
Synopsis has been filed by both of us.
We'll do that. The government can file the translation.
Like. How will you meet it?
Number 26.
I appear for the petitioner. Medical admission, medical education admission matter, my lords. Counseling is scheduled from 6th. I have filed an amendment application that the fraud played by the Karnataka Examination Authority. Earlier, they said his ranking of the 7th respondent is P3. Now they have issued an endorsement under Right to Information Act, it is P5. He is not eligible for admission. Petitioner.
Sorry, I'm so sorry.
Petitioner is deprived of an admission under the sports quota. Lords, earlier when the matter went to the Honorable Supreme Court said that if I am eligible in reconsideration, I should be given a seat. There is a direction by the Supreme Court. With impunity, they are violated and I am deprived of the seat.
Lord, I am respondent number 7. Kindly see, my lord.
I'm arguing the matter, please.
I'm sorry.
Kindly see the ranking, my lords, in the revised ranking list. Your lordship will get it at Annexure H, page 69. What is my ranking? Academic year is over, but there is a direction by the Honorable Supreme Court in Krishna Sharda matter that I should be given admission in the next year. That direction was overlooked by the earlier division bench. That there in 2020, Supreme Court passed a comprehensive order directing how these matters have to be dealt with. That was overlooked by the Honorable this court. No. They said that admission cannot be granted in the next year. There is a kindly see the directions of the Supreme Court, my lords. I have passed on that judgment on the last occasion. Please, my lords. That was not applied in my case. Please, my lords. My lords, may kindly turn to the revised this seniority list at page 69, Annexure H. I have filed an amendment application that is pending, that I have brought out two RTI documents which show that examination authority was not fair in dealing with the matter. Shall I pass on a brief synopsis, my lord? No. This was for 2022 admission, my lords. Shall I read, my lords? Page 69, your lordship may kindly take the seniority list in sports quota. It is applicable only for Karnataka state because these rules are only for Karnataka. Page 69, Annexure H, revised ranking. My lords, I am at serial number 29. Series Srikanth, the petitioner before this court, she has won a silver medal in the National Swimming Championship. P4. That is relevant, my lords. P4 at page 69, Annexure H. The seventh respondent is at in the next page at 71. His serial number is 129, P5. He is only a participant. I have won a medal. P Annexure H, page 69. I stand at serial number 29. On the right side, preference eligibility is at, I am noted as P4 silver. I won a silver medal in the national championship. Then insofar as this seventh respondent is concerned, at page, he is at serial number 129 at page 71. 71 medals. Satvik Shivanand. He is in P5. He is only a participant in the national championship. He has not won any medal. Now he has got a seat and I have not got a seat. He is selected. Yes, my lords. Initially, please, my lord, he is only a participant. And it's an admitted fact. Please, my lord. He is studying, he is in the second year.
I am the, kindly see, my lord, the order at annexure P. I'm just clarifying, Lord, on this point.
I will argue the matter on facts. It requires.
No, because this is fourth or fifth round of
No, no,
litigation,
I
Lord.
will-
The honorable court dismissed the
not
writ
fair.
petition. He withdraws the writ petition.
I will argue the matter.
Please.
The lordship may kindly turn to page 84, the first order of this honorable court. His admission was challenged by another candidate. This seventh respondent, admission and other two other parties admission was challenged in this writ petition. Page 84, my lords. The similarly situated candidate like mine, I challenge this. Yes, he is the seventh respondent before this honorable court. And the certain directions were issued by this honorable court. Your lordship may kindly skip to paragraph number 15 at page 93, internal page 10 of the judgment. Aditi Rao was another candidate. She had challenged. Your lordship may kindly take para 15, turn to para 15 at page 93. I read only two paragraphs, my lords. It is. Sorry. Please, madam. In the meanwhile, amendment application, if is allowed, I have got the amended petition also. Only one ground I have raised, that RTI, they have clarified. Yes, two IAs I have filed for production of documents, only for production of documents. IA number 1 of 2023.
It cannot.
Please.
It can be taken up along with the main.
And I will file the amended petition, my lords. Yes, yes.
Please.
Amendment, I will pass on the amended petition, my lord, since it's tomorrow.
Taken up.
Monday, for 6th is the counseling, my lords.
No.
Friday it can be taken.
This,
6th, my lords.
this is 2
Sixth.
years old matter.
Please.
2 years old matter.
There is a direction to the
Urgent.
Supreme Court in this matter. MBBS, my lords.
This is
Two directions are there by the Supreme Court.
of 2022,
22's matter.
22 matter.
No, Monday let it be there. I will argue the matter because counseling.
To upset the entire NEET list for
No, no,
2 years.
No. Yes, the other time, the division bench
There
said
is a Supreme
time
Court
is over.
judgment, there is a Supreme Court order, my lord, saying if you are eligible, the respondent number 7 is eligible even otherwise on general merit, his seat will not be disturbed. Last time, Lord Lordships recollect that I had made a Lord submission that if my seat is not disturbed,
why
because
my
Honorable
recollection
Supreme
is
Court
feeling
kindly
shy,
allow
I
me,
permit
kindly
you
allow
to
me.
argue.
I am not shying away, my lord. I am saying the Honorable Supreme Court has already disposed of, my lord, a matter saying that don't disturb his seat. Again, my lord, he wants to agitate and
No.
try that Supreme Court order before my lords.
There is
It is
no-
also, my lord, I have produced that order. Yes. Sorry, I am studying and that should not be disturbed. No, he says.
My lords, I made a statement on the last occasion.
Honorable Supreme Court says don't disturb his seat even if he is otherwise eligible under general merit. And there is an endorsement which he has produced. Sorry, my lord. No, he is saying, Lord, my seat
No,
should
I am
be
not
given to
saying
me.
anything.
Then, my lord,
my
why should
lords-
I be here?
My lords, I
If he
stated at
makes
the
that
bar
submission, my lord,
that I
let
will
me
not
go.
disturb his admission.
If
I stated at the bar two occasions back.
That may be recorded, my lord, I may be dispensed
Why?
with. And
He-
I am dragged into
He
litigation.
has
my
to
lord.
come under Krishna Sarda's judgment. 28.
Your lordship, kindly, seal number 50, your lordship.
My lords, amended petition, I may be permitted to file it now. my lord.
Lordship, seal number 50, your lordship. Pertaining to contempt matter, today specifically posted for the BBMP to file their affidavit. Till yesterday, they are not filed the affidavit regarding shifting of shops. Your lordship.
Court officer, ತಗೊಳಕ್ ಹೇಳಿದ್ರು.
number 43. That one after relating to pollution control board chairman. His tenure is only till November 24. His tenure is only till November 24. What they have done in the meantime, this honorable court convened division bench. I directed that his tenure is secured till November. In the meantime. they-
Tenure of
Tenure as pollution control board.
pollution.
Yes. In the meantime, they have removed him from office on an inquiry. Court had said you can conduct an inquiry. But Supreme Court also said, since tenure is secured till November 24, we declined it. They have intentionally removed him from office without adherence to natural justice.
So what is the request?
Not taken up at the end of the list. It's listed at 43.
Specifically. My lord.
8 we may take up.
Please, no.
28,
That is on
Friday.
Friday, if a time is fixed.
In the second half, we'll take up.
Second
Lord,
Everybody is ready.
We are preparing statement of objections. We have received the instructions,
Not filed. it.
not filed.
My lord.
File it.
Please.
They are running against time.
Yes.
Please.
It
So
was
when you will-
specifically listed today for that purpose itself.
When you will file?
By
9th shall we keep? 9th July.
9th, please.
9th will be originally. Middle of next.
9th.
week.
9th July, my lord.
5th July,
Please, my lord. By the time.
5th July,
Please.
5th July.
My difficulty is also the Supreme Court would reopen on the, say, on the 8th. Today, your lordship has specifically actually listed the matter where, say, the Advocate General, if your lordship recollect, in fact, on the 13th, the Advocate General specifically said that they'll file the objections, say, by today.
Let the objections are not filed.
Let them take their own time. In fact, your lordship, if your lordship can hear us okay on the stay itself. Otherwise, in spite of there being a specific order of, say, specific order by the Supreme Court itself, in spite of that, in defiance of that, okay, actually, they've taken us out.
November is that, November is not that near, it is.
My lordship, the other difficulty is, let's say, 310 files have been cleared just the day before the matters listed. They knew that the matters listed on the 12th night.
But
At
when
11 o'clock, they
will-
cleared it, your
will
lordship.
Give in advance.
Please. I shall.
So
My lordship may have it on the 28th.
you are
itself.
coming from Delhi.
Please, lordship.
So Supreme Court opens on 7th, we'll take
Please,
up
lordship.
5th.
My lordship,
2:30, Lord.
I will take up it.
Please.
And not one request on behalf of the members of bar. The matters, they wanted matters to reach more before your lordship.
Reach more.
They were eager to get a hearing before your lordships.
We are hearing everybody.
Yes, at least if the list is completed.
The difficulty is that when the matter is the contested matter, we can't curtail time. That is the only thing.
But
So one
today-
matter stucks up and board hold is arrested.
Because when I came, lot of members requested, if at least the admissions could be finished fast. That is one request.
So we will not be that fast to do injustice to your members. That is the only. We'll try to be as fast as possible.
Please.
Sure. Thank you.
May I need to mention, my lord?
Yes.
Serial number 67. I'm party in person appearing in that matter. There is some urgency also in that matter. This medical counseling, there is a public interest involved. The counseling is scheduled to commence from the 6th of July. Therefore, my lord, there is some urgency. Last time also I had made a mention and my lord had fixed this date. It is that serial number. My only request, my lord, is can be taken up on any other day. But I have filed an IA for direction.
When the counseling is going to take.
Scheduled to commence from the 6th of July. But that IA, my lord, if it can be listed for hearing on interlocutory application either. on-
What is the subject matter?
My lord.
Admission.
Yes, for admission, counseling will start, my lord, on the 6th of July. The counseling for admission starts on 6th of July.
So that MBBS matter.
MBBS, not that matter. That is a different matter. This is a different matter. This is in public interest which I have filed.
Public interest.
Yes, this is a public interest. I am appearing as party in person. Serial number 67.
We'll take up. Next week.
May I request one? There is an IA. If it can be request for hearing on that IA, my lord, it is likely to reach. My lord. Otherwise, there will be some difficulty. All the time, it is for final hearing. It can be listed on that hearing for that interlocutory application. IA for direction, which I have filed, my lord, in 3 months in advance, hoping that it will reach. If it can be listed on that hearing on a interlocutory.
You are also advocate.
Please.
So whatever your president of bar will say, we'll take up. Either I or main matter. We'll take up in any.
main matter, my lord, again on that day I'll be forced to make this submission again, constrained to make this very sufficient, my lord, either at 1:30 or 2:30.
We'll take up.
Please.
All matters we'll take up. We're trying to take up all matters.
Please,
Your matter may go to 4th.
4th of July, oblige.
And 2:30.
Number 17, passport matter.
Yes, what is it about? That.
70 or 17?
Oh. We are dismissing this and approving this timetable for election. Let the election go on. We'll pass the orders. How can we set the clock back? It is already progressed, Mr.
No, my lord, administrator appointed on 27/10/2020.
So what relief do you want and what relief can we grant?
Election should be completed at least next 2 months.
That is statutory stages in the election program. So all are to be exhausted in terms of the time limit.
My lord, all notices are.
Inviting objections, preparing of list of voters, final list of voters, then time for filing nominations, then scrutiny, rejection, then propaganda, this.
3 notices are issued.
In all elections, the stages are now statutory. You know that.
Agree, my lord, but the notices are issued, my lord, on 12/10/2023, 23/12/2023, and 29/1/2024. Only issued as per section 28B3, my lord, election should have been held within 6 months.
So election program is already started. They are it is underway. It is not possible to interject. We are approving that. Yes, I'll pass the order.
File a official list of documents.
Only possible. Page number 62, my lord.
Yes,
29/1/24, they already issued a third notice, my lord.
yes, we have seen. It was argued last
They
time.
filed an objection, 181 objection all been filed.
It was argued last time.
Already objection filed by the ineligible voters, my lord. Then they have to hear. the
But then now
objection.
they have started election since which the month? May.
No, my
We
lord,
are in
this is
June.
January, my lord.
Let us,
24.
let us, whatever it is, where is that program?
Page number 62.
May, 16th May.
62, my lords. No,
16th May 2024, it is started.
documents.
Under Rule 13(2)B, 2A, notice to the ineligible members, election date, then list of then last date of filing of objections, 31st May. Now we can't interject and set the clock back.
62 of the list of documents which are submitted, which say election commission has written a letter to.
You want the order to be dictated in open court, then we'll dictate it 11 tomorrow. Be here tomorrow. That is the only you are driving it. Only thing you are driving it that you should dictate the order in the open court, not in chamber. We are dictating chamber orders in chamber to save the time and to see that the matter reaches. If you insist here, we are capable of delivering the order here right and now, of any length. Yes. Of any length of the order, we can dictate here only. It is only to see that the all matter reaches and the board progresses without any hindrance. Many matters we are dictating in the chamber. Yes. So don't be under an impression. And don't force the court indirectly to dictate the order on the dais. Tell frankly that we want the order to be dictated.
Apologies.
And all these things were argued last 3 times, Mr. by your senior counsel. There must be a limit. You want time, say directly. You want the order to be dictated here, say directly, not indirectly. Yes.
And permission. List number 2. Serial number 1, Mr. Ramabat K for withdrawal of appeal.
What is it?
It will be called after 1 week, my lord. Because I have tried memo.
So what is the objection?
Here, thing is last project, I have filed a memo for withdrawal of the writ appeal itself. Now I have filed another memo to retire from the case, that will be called after a week.
What? So you're filing fresh memo,
I filed a retirement memo today morning.
retirement memo.
That's why that will be called next week.
So learned counsel files retirement memo, he is permitted to retire on behalf of
Appellant.
appellant.
Yeah,
Notice,
that's some other-
notice shall go to the appellant to engage another learned advocate in place of the present one. Full stop. Notice shall be returnable on 25th July, next.
Great.
Okay.
This cell number 2.
What is it?
The matter about the fourth picture of the demo GMC, the auction, my lord. They thought that it could be remanded for reconsideration. Please have been considered.
For orders on 28.
That's 2 and 2.1 are identical.
28 notified 11 for orders.
I'm for respond number 3. Respond number 3.
8/6 at 11 AM. For orders.
This is cell number 3.
They appear for compliant.
Compliance. affected.
Direction is complied, my lords. Liberty may be reserved to challenge the endorsement. my lords.
So convey to cooperative council. At tomorrow at 11 will start with.
Complied, my lords. Liberty may be reserved to challenge the endorsement.
Learned advocate Mr. So and so states that the directions on a single judge brought under this contempt petition are complied with, therefore nothing survives in the
Liberty may be reserved to challenge the endorsement.
contempt petition, there it is accordingly disposed of. At this stage, it is requested that since the complainant is aggrieved by the endorsement passed, liberty may be reserved to challenge the same. Full stop. Such liberty is reserved by instituting independent proceedings in accordance with law. In respect of it, this court does not express any opinion on merits.
This is cell number 4. Office objection matters. First time, Mr. Prashant Rao, party in person.
So we grant 3 weeks time in all matters.
That one, make a submission. Statement is-
First time. Second time also 3 weeks. Third time also 3 weeks.
3 weeks, 4 weeks.
Fifth time,
Jan, 3
Number
weeks.
9, fifth time.
all out.
Cell number 9. Sharan Majige, for fifth time.
Memo for withdrawal, my lord. I'll withdraw the petition.
Withdrawing, learned advocate Mr. Saran M. Majage seeks permission to withdraw the present writ petition, dismissed as withdrawn. In this regard, it renders memo whereby it is stated that the petitioner has instructed the learned advocate to withdraw the petition, disposed of accordingly.
Grateful.
The memo shall be taken on record. 10.
Cell number 10. Mr. Mahendra Gowda, fifth time, office objections.
Unless the office of is removed within 2 weeks, the petition shall stand automatically dismissed without reference to or order of the court.
This is cell number 11 for sixth time. Mr. Karthikeyan BS. Karthikeyan BS.
My lords. My lords, I'll comply within two days, my lords.
All right, learned counsel states that the office of observance will be complied with within 2 weeks. 2 week times is granted.
Cell number 12.
The
Mr.
objection was,
Murugesh Vicharity.
objection was to serve a copy to the claviator. It has been complied with.
Complied with.
Yes, sir.
Learned counsel says states that the objections are complied with, registry shall examine and thereafter place the writ appeal for admission hearing. Yes.
So number 13, Shri A.C. Balraj.
If the appellant, my lords, the translation copies are all ready. Just 2 days, my lords, I'll comply.
Learned counsel states that the office of decisions regarding translation and other left out shall be complied with within 1 week.
Please, my lords.
Next.
Number 14,
1 week time is granted. It could be 2 weeks time is granted.
14, Mr. Chokka Reddy.
Yes. So unless the office of decisions are important, complied with within 2 weeks, the appeal shall stand automatically dismissed without reference to or order of the court.
This for 8th time, seal number 15, Mr. Murugesh V. Charity.
15 and 16, your lordship, kindly grant me a week's time, your lordship.
Weeks time.
Yes.
15 and 16, learned counsel for the appellant 6, a week's time to comply with the office of decisions. Such time is granted. Next. 17.
Number 17, office objection along with council submission. Mr. Deshpande Amit.
Appearing for complainant, my lord.
Pardon?
Appearing for complainant, my lord, on behalf of Amit Deshpande. In this, my lord, the office has raised an objection that there is a delay of 8 months, my lord. We will file necessary application, my lord. Emergent notice may kindly be ordered in so far as the accused is concerned, my lord.
Pardon? What is it? So aspect of limitation shall be examined by the court. Office of decision in that regard is dispensed.
Please, my and emergent notice may kindly be ordered, my lord.
Next.
Seal number 18,
My lords, I
Ajit A. Shetty.
My lords, I beg to appear for the petitioner. My lords, the only objection that remains, my lords, is that certain manuscripts are there which are to be typed. My lords, I have made a statement that, my lords, I am not relying upon any of those manuscripts.
The office objection regarding typing of the manuscripts is dispensed with. Full stop. If the counsel is to rely on the document, subsequently court may ask for the typed copy. Registry is at liberty to place the writ petition for admission here. Next.
So great.
Seal number 19, Mr. Bhargav N. Seal number 19, Mr. Bhargav N.
Office objection shall be complied with within 2 weeks, failing which the petition shall stand dismissed automatically without reference to or order of the court.
Seal number 20, Mr. Yatish KJ.
When you will comply with?
Annexure 3 to 5 already filed the better copy and the typed copy has already complied.
Copy of?
Typed copy of Annexure 3 to 5. I have filed that.
Already filed.
Yeah, already filed.
According to learned counsel for the petitioners, typed copies are filed, therefore office objections are complied with. Registry shall examine the compliance and then place the appeal, place the petition for admission here.
Please. Number 21, the Vijay Kumar. Number 21.
So same order 21, failing which automatically is 2 weeks.
Number 22, the Rajesh Shettigar. The Rajesh Shettigar.
On this case, my lord, this
Respondent number 1.
photographs, the original photographs, they have respondent produced, my lord. Along with the objection, they have filed, which is produced. my lord.
Colored photo.
That's my subjection, submission. my lord.
Colored photo.
Sorry, my lord.
Colored.
Not, my lord, Xerox copy. They have served me, along with the objection, that is the document, they have served to me, my lord.
Dispense with.
Yes, my lord, that is.
Office objection regarding production of the original copies of the photograph.
Photographs.
Is dispensed.
Please. And another one is that, my lord, that is, I am not reliable on the document, my lord. That's the submission, sale certificate. That also produced by the respondent along with the objection.
Objection regarding supplying of type copy is dispensed with clarification out that if learned advocate relies on such documents in course of the hearing, the court may require the type copy. Yeah.
So number 23, the Varadraj Ranganath. Number 23.
Same order, 2 weeks Telling which without reference to law, yes.
December
My
24th.
lords, in this case, I have for appellant, my lords. My lords, there were the two objections what has been office has raised, my lords, with regard to the delay, my lords. My lords, what has happened is the matter was heard on 19/4 and it was in the open court, it said it dismissed. Thereafter, from
4 of this.
23, my lords. And thereafter, what has happened is on 24, 2023,
Lightening us.
no, my lords, 24, 2023 till 29, 9, 2023, the matter was reheard. my lords. Thereafter, the main matter, whatever was it, the order was released on 10/11/2023. We applied for the copy on 15/11/24/23, and the the order was released on 17/11/23, which was delivered. Now, we had calculated the delay from 17/11/23 to 27/5/2023. So according to us, it is 163 days is a delay, my lords, because the order itself was released on 15/11/2023. That is a one objection, my lords.
So what is review is pending.
My lords, it is a writ petition, my lords. In the writ petition, it is an order,
So then delay in what?
delay in filing the writ appeal, my lords.
Writ appeal. Oh. But then you file formal application.
We already filed an application for condonation of delay calculating up to 163 days, my lord. But the office is raising, no, you have to calculate it from 19/4. Since the order has been passed,
The interim application for condonation delay shall be circulated, notwithstanding the office order.
my lords, there is one more objection, my lords, with regard to translated copy of a portion of in page number 1.
Notwithstanding any office order.
My lords, for admission next week, my lord, for any admission for next week, my lords.
It is, sir, once we say that within 3 days.
Public.
See that all the circulations are within week or. We'll see on that.
3 days. Public.
Number 25. Mr. Raghavendra Ji Gayatri.
Yeah, for the appellant, my lords. Lords, the first objection which I've given submission is that, my lords, color photographs are to be published, my lords. Lords, I have put annexed the copies which was served on me, my lords, and I'm not relying on. That's why I'm seeking for dispensation of it, my lords. Lords, second thing is that, my lords, I have filed IA, my lords. I have also mentioned in my affidavit. In my opinion, my lords, delay won't come for the reason that 7 February was the impugned order, my lords. Then I moved memo for being spoken to, and operative portion of the order came to be modified on 18th of March, which was released on 15th of April. So 15th, I have filed on 27th of May, my lords, within 1 month, because immediately after vacation. So delay may not come, my lords. Office has told delay has come, that's why I have filed, my lords.
So delay application shall be circulated irrespective of.
No, it is put up, my lords. Today delay application has been put up, my lords.
Put up. So what is the delay?
My lords, they are telling, my lord, they are calculating it from 18th March, my lords. And they are telling, they have mentioned in cause list as 7. I was instructed it was 11.
According to you, what is the delay?
No delay, my lords, because 15th April is the date of scan of the date of release of the order, my lords.
Then let it be notified tomorrow, day after tomorrow. Come
Much
day
obliged,
after. We'll go through. Give me. I. Day after. In
Much
regular-
obliged, much
In
obliged.
regular board.
Well, my lords, the council submission may be accepted with respect to office objection that has raised with respect to photography.
Yes, directing listing. On that day, we'll deal with the entire petition, entire question of deal.
Grateful, my lords, grateful.
Still number 26 for final hearing.
Here for
So
this.
government review petition.
I appear for the petition.
What is this? That review.
Prepared a list of dates, my lord. Prepared a list of dates.
List of date was there, probably, earlier.
Sometimes, my lord, it gets missed, so I'm therefore, my lord, I prepared. Same thing. I added, my lord, two small information which was not there.
Next. This matter, the petition, the respondent.
Give the events, yes.
Yes, the respondent filed an application for quarrying lease on 23/4/2011. A registered quarry lease was executed in favor of the respondent. Which is in survey number 16 of Pullasandra village. Kortigere Taluk. On 29/10/2014, Assistant Conservator of Forest, Bangalore Rural Division, writes a letter to the Deputy Director of Mines and Geology, stating that quarrying lease of the first respondent is within the Koretigera Betta block, which is a notified forest.
This is within,
Koretigera Betta block,
what is that?
that's a forest block. Notified forest block. And that, as per the judgment of the apex court in Godavarman case, no non-forest activities could be permitted within the notified forest. Based on that letter, my lord, Deputy Director of Mines and Geology on 2/9/2015, 15 cancelled the lease.
Pardon?
Cancelled the quarrying lease executed in favor of the first respondent. The respondent filed a revision before the revisional authority, and that came to be dismissed on 2/11/2015.
Two 11.
2015. Thereafter, my lord, that both the orders of the competent authority as well as the revisional authority came to be challenged in WP 51325 of 2015 and 16/11/2015, which is the impugned order in this review petition. Last, may kindly see in the impugned order, there is a specific contention taken by the state government in para 4. The last, may kindly see. There is para 4 of the order in page number 23. Internal page number 3. Of the review petition.
Of the review petition.
Review petition. 23. The impugned order starts from lot 21, annexure 9. Para 4, married. We accept the contention of so-and-so that in forest area, no non-forest activities could be undertaken without the consent of central government. Nevertheless, the question involved in this case is whether the area concerned is forest or not. Then, Lord, the land is a part of survey number para 6, Lord. The land is a part of survey number 16 of Pullasandra village, Gulur Hobli, Tumkur Taluk, measuring 71 acres, 21 guntas. In the records of rights of the land was declared as pasture, that is Goma land. Sometime in the year 1994, the state government transferred the land to the CND, etc. land. Thereafter, in para 11, in page number 25, 10 and 11, 10, Mr. So-and-so strenuously argues that the area is a minor forest and therefore no non-forest activities could be conducted without concurrence of the central government. In his endeavor to make home his point, he relies upon the notification dated March 4, 1936, issued by the government of the princely state of Mysore in exercise of power under Section 35 of Mysore Forest Regulation. This is very important, Lord. Before we adverse the said notification dated March 4, 1936, we refer to the provisions of Section 35 of Mysore Forest Act 1900. Whereas, Lord, this very notification was not adverted to. Having said, before we advert the said notification dated March 4, 1936, in the entire order, this notification was not taken into consideration.
March 4.
So,
What is the date of notification?
4th March 1936.
1932.
36. That was produced during the course of submission. Also, my lord, I have produced that document along with an IA before this honorable court on 23rd February 2022. Along with the IA. In page number 6, the 4th March 1936 notification is produced, in which, my lord, page number 6, document number 1. Your lordship have it. Typed copy is at page number 7. Last may kindly see. Here it is clearly notified. The government of His Highness Maharaj of Mysore are pleased to declare under provisions of Section 35 of Mysore Forest Regulations 1900 that the land the units of which are described in the schedule annexed here to shall be continued a minor forest under the name of Koratigara Betta Minor Forest Black in the Magadi and Tumkur Taluk for the purpose of rules for management of minor forest issued with government notification, so and so, 11th April 1929. Last may kindly see, under that Pulla Sandra, the very village, survey number and class, that is Gomal 16 assessed west.
Which page?
Page number 7 is typed. Originally is at page number 6.
So what is this? Documents are produced.
Document number 1 is the notification notifying this survey number 16 as a minor forest, known as Korettigera Betta minor forest block. In page number 6 of the IAM lot. Your lordship would see, and in the column village, Pulla Sandra.
Where is that page, please?
Document number 1, page number 6.
What does it show?
It shows not the village, survey number, area, and the name of the block, which has been declared as forest. That is, survey number 16 of Pulla Sandra has been declared as Korettigera Betta minor forest block. This very notification was referred to in para 11 of the impugned order. Then, Lord, there is an error to this effect on the face of it, Lord. This very document, had it been considered, the decision would have been otherwise. Then coming to para 13, page number 26 of the impugned order. It is pertinent to note here that the Mysore Forest Act 1900, there is no reference to minor forest. Section 211 defines state forest. Section 212 defines village forest. And section 213 defines district forest. There is no description of minor forest in the said act. That is also wrong, Lord, as per Annexure B, page number 36.
Hmm.
36 is the notification dated 11th April 2029. There it is clearly mentioned, the government of His Highness Maharaj of Mysore are pleased to make the following rules under Rule 35(3) of Mysore Forest Regulation for the regulation of the use of the forest produce and pasturage in the area placed under special protection hereinafter called minor forest under the provisions of the said section. Therefore, Lord, this observation made by, with the due respect, I submit, Lord, this observation is contrary to the enactment. Then, Lord, 14, para 14, I go back to this para 14 of the impugned order, page number 26. We must, however, record that under section 7 of section 35 of the said act, the government had the authority to regulate or prohibit quarrying of stone or gravel, the burning of charcoal, the smelting of ore, or the boiling of charcoal. That is under 35, section 35, 7. Then, Lord, para 18, page number 27. We repeatedly requested state to produce any document to show that this area was even included in the forest area. There is no material on record to show that it is a part of forest area. Lord, it is contrary to the record which we have produced. It is there on the file, Lord. We have produced this very notification during the course of argument. This has not, though there is a reference to that effect in para 11, that has not been considered. Thereafter, my lord, a reliance was placed on the judgment of the divisional railway manager and others versus the state of Karnataka and others in writ petition number so and so, which is misplaced. It is nothing to do with the present case. This is pertains to survey number 1 of Lord, a different area and different district. Then thereafter, Lord, your lordship may kindly peruse para 20. We are informed that an application for review of, no, I'm sorry, my lord, I'll read from 19 itself, para 19 itself, page number 27. Mr. So-and-so further draws our attention to an unreported decision of this court in case of so-and-so. In the said decision, the state government wanted to prohibit the railway authorities from using a portion of the said survey number for non-forest purpose. It was alleged that the railway authorities unauthorizedly established a goods terminal and wanted to lay down railway track illegally. The Honorable Single Judge held that the land covered by the said survey number was not a forest area, as it was never declared as a reserve forest. The decision of the Honorable Single Judge was affirmed by the division bench by the judgment and order dated January 7, 2010 in writ appeal number 3805 of 2009. We are informed that an application for review of such order was proved abortive. Ultimately, the Supreme Court of India dismissed the special leave petition under Article 136 of the Constitution of India. We thus got a judicial pronouncement in relation to said survey number 16 that was never declared as a forest. This is wrong. Para 21 is, whereas this judgment relates to survey number 1 of Kadugadi plantation area, Bidralli Hobli, which I have placed it on record. Last may kindly peruse the judgment in WP number 14649 of 2007, which I have placed.
What was the judicial, this one?
Page number 3, my lord, para 2. It is stated that the petitioners are all employees of the Indian Railway, and it transfers that the third respondent had in the year 1981 after deciding to establish industries in the land bearing survey number 1 of Kadugodi Plantation Village, Bidralli Hobli, Hoskote Village, had granted permission for establishment in para 3. Survey number 1, Kadugodi Plantation Village, Bidralli Hobli, Hoskote Taluk. This is nothing to do with the present petition. Therefore, Lord, only this judgment was rendered based on the judgment relied on by the council in WP number 14649 of 2007, which is misplaced. Therefore, it is erroneous, is my submission.
Lord, my learned friend submitted that, my lord, the minor forest is defined under the old, my lord, Mysore Act, Forest Act of 1900. Please have a look at, my lord, that act. Copies. Entire act does not, my lord, define minor forest. There is no reference to minor forest, my lord, in the entire act. That is what, my lord, the division bench earlier said. And rightly so. This is the act, my lord. Please come to, my lord, page 765, where there are the definition, my lord. Section 2 is, my lord, the definition section. Please come to, my lord, 2, 11, 12, and 13. There is no minor forest in the entire act. And that is, therefore, my lord, the division bench was right in saying entire act does not, my lord, provide for a minor forest at all. But what is stated is, please come to, my lord, para 35, section 35.
Is
My lord, section 35, my lord, I pointed out, my lord, section 2, subsections 10, 11, and 12. That's a definition section, my lord. State forest, village forest, district forest. So, my lord, division bench was right in saying, my lord, the entire act does not provide for, my lord, a minor forest. If, my lord, the act provides for, my lord, a minor forest, let my learned friend show it, my lord, it's not there. I have gone through the whole of it. Now, my lord, please come to, my lord, the regulations which have been made in terms of this act, my lord. Please take the review petition. My lords may come to, my lord, Annexure B, page 30 of the review petition. English trans, my lord, the typed copy is at page 34. What, my lord, the notification says is, sorry, page 34, my lord, is the typed copy. Same thing, my lord, is there in, it's also clearly visible, but better, my lord, would be the typed copy. 34, my lord. My lords may look at, my lord, the preamble. Government order dated 14th of July, 1924. Sorry. 34, my lord. My lord, read. The government order number so and so, dated 14th of July, 1924, sanctioning tentatively or 3 years, the scheme for the formation of minor forests and directing that the forest regulation be amended by rescinding the term district forest and introducing in lieu thereof, the term for minor forest in conformity with this above scheme. My lord, that amendment has not come at all. Now, please come to, my lord, page 36. What, my lord, has been done is, they, my lord, want to, my lord, say forest produce, my lord, which are available, they, my lord, regulation is made. That's the continuation of, my lord, page 34 at 36. The government of His Highness, the Maharaja of Mysore, are pleased to make the following rules under section 35(3) of the Mysore Forest Regulation. For regulation of the use of forest produce and the end of the pasturage in the areas placed under special protection, hereinafter called the minor forest under the provisions of the said section. The rules shall apply to all districts, but shall not affect the rules in force at the time, for the time being in force, defining the privileges of rayatas in the district forest and the rules defining the rayatas privileges in the district and the districts of Kadur, Shimoga and Hassan, so far as they relate to taluks and part of taluks specified therein as Malnad, except to the extent defined in the rules hereunder. Then, my lord, please come to my lord 1 in the same page. A minor forest will consist of such unassessed garment land of a village, of a group of villages, as form a compact block and admit of and are fit for being easily conserved and managed by the forest department. Then, my lord, please come to my lord clause.
Which clause?
My lord, I was at page 36, my lord. My lord sees, my lord, 1. At the top, my lord, page 36, at the top, my lord, garment of His Highness Maharaja. My lord, I read that, my lord. I don't know whether, my lord, when I pointed out this, saying that, my lord, for the pasturage, garment of His Highness, the Maharaja of Mysore, are pleased to make the following rules under section 35(3) of the Mysore Forest Regulation.
Pasturage are called minor.
Pasturage in the area placed under the special protection, hereinafter called the minor forest. So, my lord, pasturage under the notification, not under the act. Under the notification, my lord, they call, my lord, the pasturages as minor forest, under the provisions of that. And for what purpose is this? This is, my lord, only for the purpose of regulating, my lord, the forest produce. In fact, if my lords come to my lord clause, clause 18, which my lords get that at page 41. Same, my lord, it's continuation, but then somehow, my lord, they put one 41, clause 18. They term, my lord, pasturages as minor forest, and they say quarrying in the minor forest shall be regulated by the rules under the Land Revenue Code. However, care, however, being taken by the Deputy Commissioner, see that it's not ordinarily permitted in places where damage is likely to cause to the forest. Therefore, my lord, it is minor forest is not defined under the Act. Under a notification, my lord, they call, my lord, pasturage as minor forest, and they say, my lord, it will be regulated by this regulation. And for what purpose? For, my lord, use of the forest produce. Now, please come to, my lord, section 35. Because if your lordships look at page 36, my lord, it refers to section 35. My lord, please come to section 35 of the main act, my lord, that 1900 act. Act, my lord, sorry. This regulation, my lord, was made under section 35 of the 1900 Act. Subject to all rights now legally vested in the individuals and communities, government may for any district or portion of a district make rules to regulate the use of the forest produce or of pasturage of any land at the disposal of the government and not included in the state or the village forest. Such rules, my lord, may include 7, my lord, at the bottom. Regulate or prohibit quarrying of stone and gravel, burning of lime or charcoal, smelting of ore, boiling of catechu. Therefore, my lord, there is no minor forest in the Act. By a notification, my lord, they say pasturage will term it as a minor forest. And, my lord, that regulate, my lord, that notification itself speaks of section 35. And section 35, my lord, is for the regulation of, my lord, forest produce and pasturage. Not, my lord, of the, they don't, my lord, say that this is a forest. It's a, my lord, for the purpose of managing, my lord, the forest produce, if there is any. And, my lord, it specifically says quarrying, my lord, is permitted. Therefore, my lord, my submission to your lordships is that the contention of my learned friend that there is no minor, my lord, there is the division bench was wrong. On the face of it is not correct. Now, my lord, please come to, in fact, if my lords come to, my lord, the notification itself. Same, my lord. My lords, my learned friend, my lord, showed your lordships, my lord, the notification dated, my lord, 4th of March 1936, where
March.
yes, my lord, separately, my lord, it was given along with, my lord, that IA, my lord. IA for production of documents, my lord, my apologies. We should have made one convenience compilation given to your lordships, my lord, everything in one go. I think, my lord, next time onwards, I'll try and do that, my lord. Because my lords, may be pleased permit me to read, my lord, the top itself. Government of His Highness the Maharaja of Mysore are pleased to declare, under the provision section 30, section 35, my lord, your lordship, my lord, it is for the purpose of regulating the forest produce and, my lord, the pasturage, not of a forest. Under section 35, the Mysore Forest Regulation, that the land of which are described in the schedule annexed here to shall be constituted a minor forest under the name Korategere Betta, minor forest block in the Magadi and Tumkur Taluk for the purpose of rules for the management of minor forests issued by the government, my lord, in notification dated 1929, which I pointed out, which says for the purpose of, my lord, managing, my lord, the forest produce and the pasturage. Then, my lord, please look at, my lord, what is it that has happened? Pulla Sandra number 16, my lord, they have, my lord, the total extent, my lord, is 71 acres. What is, my lord, notified is, my lord, 35 acres. There is, my lord, large extent of land. Not only that, my lords are aware, my lord, there was that safer zone, my lord, which the Supreme Court, my lord, directed that, my lord, wherever that quarrying has to occur, my lord, stone crushers have to have, there must be, my lord, safer zone. Government, my lord, notified this very land as, my lord, a safer zone. Please take, my lord, my objection statement. My lords may take, my lord, the objection statement to the review. Page 61, my lords get, my lord, that notification. Sorry. I'm so sorry, my lord. I think, my lord, I'll remember, my lord, this. Next time onward, we'll make a compilation, my lord, of convenience compilation so that my lords may not, my lord, flip the pages from 61, my lord, of the objections. 70, my lord, is the translation. 70, my lords, come to, my lord. That's the English translation. Ullasam. Next year R4 anta barutte. Sorry.
Yes. Yes.
My lord, this is a notification issued by, my lord, the state government. In the letter cited under at reference, my lord, sorry, bottom, my lords, get that. The state pollution control safety zones in various villages of Tumkur have been identified them under metalliferous mines regulation 2012 and the details of which are here under. My lord, top, your lords, get prescribing the safety zones to stone crushing powder making units in the taluks of Tumkur. My lords may come to, my lord, page 75. 75. Pulla Sandra, 10, my lord, acres. My lord, government land has been notified as a safer zone. Page 75. last page, my lord, of that notification. 75. I think, yes, my lord, sorry. If your lordship is Pulla Sandra, Tumkur district, my lord, same survey number 16, my lord, survey number 16 comprises of 71 acres. 35, my lord, 36 acres is, my lord, is for that pasturage, my lord, for under the notification, my lord, for forest usage of, my lord, I mean, for management of forest produce. The remaining, my lord, stone crusher unit also is permitted, and my lord, there are stone crusher units which have come up. The land in question, my lord, has been granted. My submission to your lordships is that, my lord, no way, my lord, the total extent of the land, my lords may come to, my lord, page, my lord, 64. Sorry. RTC, my lord, sorry. 1/4, my lord, English translation at 1/5. Page 14, at 15 is the English translation. If your lordship sees, my lord, Pullasandra village, 4th line, my lord, from the top. 16, my lord, survey number is the next line. 71 acres, 21 guntas. Page 1/5. Out of, my lord, 71, 35, my lord, is for management of, my lord, the forest produce. Balance, my lord, is available. They have given, my lord, 3 acres. I have been, my lord, running, and 10 acres, my lord, for a safer zone, my lord, there are stone crushing units. And now, my lord, please look at, my lord, annexure R3, page 43 of the very volume, my lord, which your lordships are holding. Four 3, my lord, annexure R3. Yes, my lord, 4/3, 43. Details of C and D class category land, 1,31,866 hectares free from all encumbrances, which has been transferred in the first instance, the Revenue Department to the Forest Department for formation of land bank in the Forest Department. If your lordships turn to, my lord, page 44, this is, my lord, subject to Revenue Department taking back the land. Next page, my lord, 44. The land bank, my lord, is subject to the following condition. One, sorry. After detailed examination of the proposal, the government hereby order for transfer of 1,31,866 hectares as detailed in annexure to this order to the Forest Department for the purpose of formation of land bank subject to the following conditions. One, Revenue Department can take back this land from the land bank in case of necessity of land to the government for any public purpose. Land transfer shall have to be continued as C and D category land, and no notification shall be issued classifying this land reserve forest under the Forest Act. In the event of releasing the forest area by the Forest Department for mining activities under such circumstances for the purpose of growing compensatory plantation, C and D category lands from the land bank can be released to the Forest Department as compensation for the same. Therefore, my lord, my submission to your lordships is that, my lord, this is not a minor forest. There is no minor forest at all. The division bench, my lord, rightly held that the entire act, my lord, does not, 1900 act, my lord, does not provide for, my lord, this. Now, my lord, your lords may ask me. 1963, my lord, there is a new Forest Act which has come into force. Can I request your lords to look at, my lord, page, that new Forest Act of 1963? section 35. Adikkuno section 35, protected forest. Protected forest even ಇತ್ತಲ್ರಿ.
What are you showing?
Section 35, my lord, if your lordship sees. Because I must also bring this to your lordship's notice. My lord. It's all right. I must, all facts, I must place it before your lordship's hand. I don't want to suppress anything. Minor forest, my lord, section 35, constituted the previous to the commencement of this act. Any forest in the state which has been notified as minor forest under the Karnataka Forest Act 1900 or as protected forest under the Indian Forest Act 1927 or Hyderabad Forest Act 1335 firstly, prior to the date of this act coming into force, shall be a protected forest under this act, and the provisions applicable to a protected forest shall be applicable to such forest. Now, my lord, please look at, my lord, the protected forest. What is it that they are required to do, my lord, in respect to the protected forest?
So this is against you.
Please, my lord, this is the 1963 Act, my lord.
Against you.
This is not against me, my lord. I'll point out why. I must show, my lord, what is the provision, because your lordships must also know, my lord, that, minor forest now today is stated to be a minor, my lord, state forest. By virtue of, my lord, by virtue of the protected forest, by virtue of section 35. Now, please look at, my lord, what is the protected forest? Protected forest ಅಂತ ಇಲ್ಲಿದ್ದಾರೆ ತೆಗಿರಿ. My lord, please come to, my lord, the definition section at 213. In the very act, my lord, in this very act, 1963 Act. read. Protected forest means, section, my lord, 2 subsection 13. Protected forest means any area at the disposal of the government which has been placed under the special protection under clause 2 of section 2 of subsection 2 of section 33, or is declared to be a protected forest under section 35. Now, please look at section 33, my lord, for a minute. Again, my lord, section 33 relates to, my lord, management of the regulation of the forest produce or the pasturage. 33, my lord, subject to all rights now legally vested in individuals and communities, state government may for any district or portion of a district make rules to regulate the use of the forest produce or of the pasturage and the land at the disposal of the government, not including the reserved or the village forest. Without prejudice of generality of the foregoing power, such rules may, my lord, provide for, my lord, all these things. Please come to, my lord, 6, subsection 6 of, my lord, subsection 2. Regulate or prohibit quarrying of stone or gravel, burning or lime charcoal, smelting of ore, or boiling of katachu. Same thing, my lord, which your lordship saw, my lord, in the regulation of 1929. Therefore, this is, my lord, in respect of, my lord, the forest produce and the pasturage, not, my lord, it is not a forest, my lord, as defined under the new act or the old act. Old act also, my lord, does not define minor forest. Therefore, my lord, my submission to your lordship is, first, that, my lord, 71 acres were there. Only, my lord, 35, my lord, have been made, my lord, to be, my lord, managed under the, my lord, the notification with regard to forest management of forest produce and pasturage. Rest are not. Government itself, my lord, indicated, my lord, 10 acres as, my lord, a safer zone, my lord, for stone crushing units which are all established. 3 acres is, my lord, given to me. Still, my lord, there are another 17 acres, more than 17 acres, nearly 20 acres, my lord, which is there, which is not a minor forest or, my lord, otherwise. Therefore, my lord, my submission to your lordship says, the order passed by, my lord, the learned division bench, my lord, on the earlier occasion, there may be, my lord, what happened was, my learned friend, my lord, pointed out that there was a mistake, my lord, in relying upon, my lord, another earlier judgment. But what happened was, by mistake, my lord, they said, my lord, it is the survey number 6. It was a survey number, my lord, another survey number, which was also a minor forest, declared, my lord, under that 1900 Act. Therefore, my submission to your lordship says, the order, my lord, passed by the division bench is just and proper, does not call for any interference.
What is to be read?
In fact, during the pendency of this, a fresh lease also has been granted to me. There are 300 people working. My submission to your lordship says that, my lord, today, what, my lord, we input, my lord, farming, we can't get it. Ultimately, my lord, there has to be, my lord, some industry, some, my lord, activities for people to live. There is, my lord, the crushing activities, my lord, quarrying operations which are going on. 300 people are there. Therefore, my lord, my submission to your lordship says, this does not call for any interference, my lord, reviews. The order passed by the court is just and proper. In fact, can I persuade your lordships just to look at, my lord, page 31 of the objections filed by me? There was an inspection by the deputy commissioner, page 31 of the objections, my lord. Both mines and geology, my lord, page 31, annexure R2. Conducting of joint spot inspection with regard to the grant of stone mining license in land measuring 3 acres in survey number 16 of Pullasandra village, subject. Then, my lord, with regard to the above sorry, my lord. My apologies. Annexure R2, page 31.
That was at the time of granting in the year 2010.
Maybe. I will point out all that.
It has been cancelled.
Cancelled by whom? Can the forest department, somebody, my lord, say, I will now cancel it? Please see, my lord. With regard to the above subject, in your lord, subject, conducting of joint inspection with regard to page 31, annexure R2, my lord. My lord, earlier, my lord, the office used to give, my lord, sequential numbers, my lord, for all papers. That would have been, my lord, more convenient to your lordship. Now on, my lord, I'll remember, my lord, I'll make a convenience compile. So sorry, my lord. My apologies, my lord.
31 of S1.
31 of objections.
31,
Annexure R2.
but there are several.
ಮುಂಚೆ ನಂಬರ್ ಕೊಡೋರು ಇಲ್ಲ ಇನ್ನೊಬ್ರು ಹಳೆ ಜೊತೆ ಇನ್ನೊಬ್ರು
31.
Objections to RP.
Yes.
My lord, this is conducting of, my lord, subject, conducting of joint inspection with regard to the grant of stone mining license in the land measuring 33 acres in survey number 16 of Pullasandra village, Tumkur Taluk. With regard to the above subject, in your letter referred above, you have requested to fix a date for conducting the joint inspection. Application received for grant of license for stone mining in the land measuring 3 acres in survey number 16 of Pullasandra village, Tumkur Taluk, which is a Gomala land. Accordingly, joint inspection was been conducted, and in enclosing its report is enclosed to this letter, it is opined that the joint spot inspection, that since there is objection from the public for grant of stone mining license, the file is sent herewith for taking action to grant stone mining license, subject to the condition the mining operation should not be done through the blasting or use of explosive, so on, so on. So joint inspection, my lords, may be pleased to see. At, my lord, page 33, serial number 2, my lord, clause number 2. RTC records, my lord, in the land measures, my lord, 71 acres, 21 guntas. 3. Nobody has submitted an application for proposed land. Land in the proposed survey number has been previously granted to others. And after the Duras, the remaining land is comprised of boulders. There is no, my lord, tree growth, nothing. This area is not reserved for any public purpose. There is no road, etc., etc. There is since the land comprises of boulders, there is no existence of Gomada. Tahsildar, my lord, has given a report. Then, my lord, see para 5, my lord, next page. This area is comprised of boulders, rocks. Since it is not fit for cultivation, there exists no Gomada. Since there is objection from the public, it is opined that the spot inspection that stone mining license may be granted. My lord, there is no objection. No is missed out, my lord. Kannada, my lord, I'm sorry. Justice Arvind, my lord, will be able to see para 20, page 28. Para 4, my lord. Akshepa illa, the last sentence, last line. Adu illi English translation, what they said. Objections, there's no objection. Sorry. In translations, my lord, today, our number of people, my lord, translators are very, very few. And they make, my lord. Kannada my lord, Kannada is, my lord, at page 28. It specifically says, my lord, there is no objection. That no is missed out in translation. Therefore, my lord, my submission to your lordship is the order passed by the division bench is just and proper. Therefore, does not call for it. Grateful, my lord.
So it should be objection.
Please, my lord. This is the objection statement, my lord, filed by me. All these are, my lord, documents which I have placed before your lordships.
What is the translation mistake?
That no is missed out, my lord. My lords may be pleased to see.
No,
Please, yes.
No is required or not required?
My lord, please come to, my lord, running page, spot inspection. Page 34, my lord. Sorry, there is no objection, my lord. That has come up correctly. Third line, my lord, in para 5. Since there is objection from the public, that, my lord, is the mistake. In fact, serial number 5, my lord, at page 28. I'm sorry, I should have shown that, not this. 4. ಎರಡನೇ ಲೈನು ಮಂಜೂರಿ ಬಗ್ಗೆ ಸಾರ್ವಜನಿಕರಿಂದ ಅಲ್ಲದೆ ಸಾರ್ವಜನಿಕರಿಂದ ವಿರೋಧ ಇರುವುದರಿಂದ ಸಾರ್ವಜನಿಕ ಆಸ್ತಿ ಹಾನಿಯಾಗದ ರೀತಿಯಲ್ಲಿ ಸ್ಫೋಟಕ ವಸ್ತುಗಳನ್ನು ಬಳಸಿ ಸೋನ್ಸ್. Anyway, my lord, this is all, my lord.
Lord, there is no dispute about this spot inspection or the opinion expressed by the revenue department while granting lease. Indeed, lease was granted. Thereafter, on the letter written by the assistant conservator of forest, the quarrying lease was cancelled in the year 2015. All these documents are the year 2010 while granting quarry lease. Therefore, there's no dispute about it. Even while filing this petition, Lord, though it was based on a letter written by the forest official, Forest Department was not arrayed as a party in the writ petition for the reasons best known to the respondent number 2. And so far as definition of protected forest is concerned, what was read was 33 clause 1. You'll ask me kindly peruse the definition. 213. Section 2, subsection 13. Protected forest means any area at the disposal of the government which has been placed under special protection under clause 2 of subsection 2 of section 33. What was read before the court is subsection 1 of 33. Last may kindly see section 33, subsection 2.
Without
33, subsection 2, subclass 2. Provide for placing any area at the disposal of government under special protection in view of subsequent settlement and condition as a reserve forest or for other purpose, and prescribe the conditions and penalties attendant on such special protection. Lord, it is not for the pasturage. I'll ask myself a question, Lord. If the minor forest is declared in order to regulate the forest produce, if it is not the forest, where is the question of regulating the forest produce? That is exactly for the reason under section 35 of the Forest Act 1963. It is classified as protected forest. And so far as declaration of safer zone in case of crushes are concerned, Lord.
Forest produce also is defined, my lord, under the Act, section 27.
No, my submission is, if it is not a forest, where is the question of regulating forest produce? My submission is, Lord, so far as declaration of safer zone in respect of crushers are concerned.
And actually,
So far as declaration of safer zone for establishing crusher is concerned, it is provided under subsection 2 of section 6 of regulation of Stone Crushers Act 2011. But in all, irrespective of any area, in all areas, safer zone shall be declared under subsection 2 of section 6 of the regulation of Stone Crushers Act. Here is a case, the quarry lease is granted within the forest area, within the notified reserve forest. And it is not in dispute that this area was declared in the year 1936. That notification is there before your lordship. And the area declared as forest in the notification dated 1936 is to the extent of 85 acres, 16 guntas. It is not 35. 85 acres, 16 gunta. Last may kindly peruse the notification. In the notification, it is clearly mentioned that Pulla Sandra area is 85 acres, 16 gunta. Last may kindly take the next document, that is RTC produced at document number 2. Page number 10. Translation is at page number 11. This is in respect of survey number 16. Total extent is 71 acres, 21 guntas. And it is declared as, even as per the revenue records, it is Koretigara Betta Block Reserve Forest. Last may kindly peruse the column number 9.
It is in 2021, my lord. Long after the judgment, all that. Earlier one we have produced. Earlier one specifically shows it is Goma. Fifteen, 16, 17, my lord, from 2010. till, my
So
lord,
this clearly shows, my lord, these documents clearly show this is a forest area. And it is in pursuance of the notification dated 36. And so far, my endeavor is to show that, my lord, there is the error apparent on the face of record in the impugned judgment. The Honorable Division Bench held that there was no minor forest in the 1900 notification. Whereas Section 35, it is clear. Section 35 of the Act, Karnataka Forest Act 1963, it is clearly mentioned that the minor forest declared in the year 1900 shall be treated as protected forest. Therefore, one cannot say that there was no minor forest in the year 1900. There are subsequent notification converting district forest as minor forest, which I have produced before this honorable court. And second error is that, my lord, placing reliance on the judgment in respect, rendered in respect of survey number 1 of Kadugodi plantation, which is nothing to do with the present. So,
Grateful, my lord. My lord, I'll remember, we'll file, my lord, a compilation in future, my lord, because it's not running page, my lord, it becomes so difficult. Ultimately, my lord, both of us quarrel and we'll go and have, my lord, one tea and then come back, putting everything on your lordship's shoulder. We'll remember, my lord, this.
Because I am accustomed to different kind. Within 1 week, one month, I'll be.
Please, my lord. No, earlier, my lord, the chief justice used to say, my lord, there must be a running page, my lord, 1 to
Running,
500, whatever.
Then
Then it becomes easier. Anyway, my lord, I'll remember this. Whenever I come, my lord, I'll make one compilation convenience so that it's grateful to you, lord. Okay, please.
So for the time being, keeping on third.
Please.
On that day, we'll see whether to proceed or to reserve or depending upon the time available. Brief facts of this case, my lord. The present petitioner, after the second PC in Maharashtra, he was searching for a MBBS seat in Karnataka. He applied for the course as required under the law with the NEET, KEA, Annexure D, my lord. They have to undergo counseling, page 21, my lord. And he has got a NEET rank of 7,19,523 in the course. Page 21, my lord. His NEET mark sheet is at Annexure C, my lord. Page 20, the previous page.
He has scored 281 marks, my lord. The next page, annexure. Continuation of annexure
We'll
D.
take up tomorrow.
Tomorrow I have an inconvenience, day after tomorrow.
Day after.
Number 28. Sharath M. Number 28.
Lord, I appear for sixth respondent.
Two petitions. First petition not is 12660. But I have sought not for an extension of time so far as the mining lease which have been done in my favor. And the second petition, my lord, 12640, my lord, is a challenge to an auction.
May I make a submission, Lord? In the second petition, they have filed an application for amendment. I may be granted some time to file statement of objection.
Right, it's an amendment petition, my lord, only on the day of
No,
filing.
no, they made certain allegations against the officials. Now I have to file my objection.
But they will be permitted to file, once the amendment is allowed, my lord, they can file their
No.
objections. my lord, to the-
That we can, whether amendment is to be allowed or not, allowed is a question
Right,
because
it's only a
the
consequential action.
maintainability of the first petition itself
One
is.
request, my lord.
When
I
the-
appear for sixth respondent. In the first matter, I have filed an impleading application.
But I have no difficulty, my lord, for the applicant to be allowed.
That impleading application may be allowed
I have
so that I will get a
I have
chance
no
to file
objection.
my objections also.
That is allowed.
Please.
In the first case, my lord. It is 12660 of 2024.
Second. But I have no difficulty, my lord.
Yes.
One request, my lord, which I had on 2nd May 2024, my lord, during vacation. Lord, on the submission of the, application, my lord, the submission was recorded for about period of 8 weeks. That expires tomorrow, my lord, the submission which was made. It was for a period of 8 weeks, my lord. If
Yes,
What
subsequent.
sub-
the submission had been made, my lord, that insofar as the ore which had been extracted, my lord, during the period of the lease, that, my lord, is subject to the monitoring committee, my lord, of the Supreme Court, my lord, which has to, my lord, sell that ore. In the meanwhile, my lord, they have conducted an auction, my lord, so far as the mining lease start being guaranteed in my favor. Now, my lord, the advocate will not submitted that they would not ensure that every measure is taken not to quantify the ore and to mark the place where it is before allowing them to start production.
So
That was not for a period of.
That
8
has,
weeks, my lord.
that has been
Can be-
quantified, Lord, I'll place it on record.
Extended, no, to be extended.
But that-
Similar
but they had-
application is filed.
It is not
Lord,
for
similar application is filed and pending before the Honorable Supreme Court.
This was a case of Mlad, the lease was auctioned subsequently and he is the successful.
No, what is to be done with the request of the council?
but they had-
Survey is done.
Survey is done, Lord.
That
The
report has to
ore
be
is
produced before your
quantified.
lordship.
I'll place the material on record along with my statement.
Because they had said that they would not allow, my lord, the operations to commence.
No,
by
no,
the
that is not correct.
No,
That
no.
is not
That is
correct.
done.
No, that is not correct.
Some urgency, my lord, if.
No,
Last
that-
may kindly peruse the order dated 2/5/2024.
2nd May 2024.
Order dated?
2/5/2024.
It has nothing to do with my operation.
Yes, ma'am.
Lease deed is already
May I
executed.
just take a lot to the last, but the third paragraph. Sir. This court is in the considered view. that The petitioner's request for interim order must be considered by the regular bench as there is no urgency. I'm sorry.
We don't have the order.
I'm sorry, my lord.
That copy is it.
The third paragraph, not if I can just read that to you. This court is of the considered view that the petitioner's request for interim order must be considered by the regular bench as there is no urgency. However, the protection of the ore that is extracted by the petitioners in the subject property and the petitioner's anxiety about safety, the learned advocate general submits
that the government will take every measure as would be necessary to A, quantify the ore, and B, mark the location of the place where the ore is stacked before the respondent number 4 is permitted to commence operations. These effective measures will be taken subject to orders of the Honorable Supreme Court in IA number 21884 of 2020, in WP number 562 of 2009. These submissions are taken on record for due compliance for a period of 8 weeks, unless otherwise clarified with the Honorable Court. If not, one is my prayer for interim relief, not restraining them from operating. That is also not before your lordship, now not to be considered. Second is not, they had said that they without resorting to these measures of quantifying the ore and marking it, but they would not commence operations. That was for a period of 8 weeks, they had said that 8 weeks expires tomorrow.
No, my lord, we have quantified the ore. That material I am placing it before the court, my lord. We can allow them to, my lord, operate the mine. We have executed the lease in favor of respondent number 4.
My prayer for interim, prayer which is to be considered by this court, is.
Lord, his prayer has been rejected by the Supreme Court. I'll place the material. There is an order by the apex court rejecting his prayer.
There was an order by the Supreme Court, but which had said you can go into the auction provision.
On next venue, we will take up.
I request
2 weeks time may be granted, my lord. There's no urgency. 2 weeks time may be granted.
Have been served in May. May I request next week itself,
My lord, my application is allowed now.
Obliged.
9th July.
may only make one request, since they have not, at least now, so far as their undertaking is concerned, they have not said anything. At least let them not commence till that date. That's
No,
all.
No, commencement is only in that area.
The order
Entire
says,
area.
Lord, we have to quantify the ore. We have quantified the ore. Thereafter, we can permit the respondent number 2, respondent number 4 to continue the mining operation. And he cannot, he do not have a right over respondent number 4's lease.
With respect to the ore,
We'll apply mind on, then you will be able to file by 4th, and we keep it on 3rd.
Very well.
3rd.
One, your last may kindly have it on 10th so that I can file comprehensive
Let them maintain
objection.
status quo till then, that's my request. They have had notice.
No,
of
We have already executed lease.
sorry, I am opposing it seriously.
10th.
Obliged.
I only request, next week, your lordship can kindly accommodate, because they should.
He is to file reply, let him file.
My lord, what they did, my lord, is on the day the petition was filed, they went in and executed the lease. My only, my lord, apprehension is.
Because he is
by
the
taking
successful
time-
bidder, he has not participated in the auction.
Is that by taking
Without,
time,
without catching, understanding the controversy, we will not pass.
certainly, my
Please.
lord.
Yes,
The request is not, therefore, they should not take time and also not precipitate. That's the only request. That's why I'm requesting in the next week, my lord.
What action they are going to take?
My lord, commencing the operations, because the earlier subdivision was.
No, he has no right over the lease area. His lease was expired and he sought for extension. That has been granted.
And Mr.
Thereafter, further
Lord,
extension.
I am the successful bidder. Lease deed is executed in my favor. I have paid crores of rupees to the government for that purpose.
Thing will happen.
His similar writ is already dismissed by the
Next week,
Supreme
my lord,
Court.
I'm not, the lordship is
8th,
perfectly right.
8th,
That's the only.
Obliged.
8th.
Lord, I will not touch that ore. That is what we have stated. Let them, Lord, give the report to the court.
8th.
Obliged.
But the amendment application could be allowed, but very,
Yeah.
I'll file the amendment petition also.
Copy. Amended, I am filing objection to the amended.
I'll
Amendment.
file this today, tomorrow.
Amendment is that implement is allowed.
Yeah.
That also.
Implement is allowed.
Amendment, we are not allowed.
Yeah.
Very well,
Because he is filing reply.
very well.
Implement is allowed.
Yeah.
Great.
May I request a copy, because copy is not served.
Number 29. Mr. Srishail Shobasappa.
Thank you.
Please, all that.
Number 29.
But appear in the connected matter, not for the appellant.
Shall I make one submission?
Not in the connected matter, my lord, I appear for the appellants, my lord, in WA 741 of 2023. My lord, in this case, my lord, I am the
mortgaging.
Before,
the-
before my learned friend comes, shall I make one request, my lord? Lord, in this, my lord, my lord, my respectful submission is, they have no local standard to continue with these appeals because they have already sold the property. Lord, suppressing that fact, my lord, they have filed this appeal and seeking interim order.
Let us,
Property has already been sold, my lord. Property is auctioned.
let us understand the facts.
Please,
What are they?
please. But for that, my lord, only they have served the copy only day before yesterday. But I may be permitted to place my objection also on record.
So you want time?
But if your lordship permit, my lord, 1 minute. Earlier also, the another company has filed.
Today, what is the request? Time?
But I filing, if your lordship permit, my lord, I will place this,
File it.
please.
Copy of-
Signature ಹಾಕ್ಲಿಲ್ಲ.
Copy.
ಕೊಟ್ಟಿ ಕೊಡಿ. Signature ಹಾಕ್ಲಿಲ್ಲನ್ರಿ. Signature ಹಾಕ್ಕೊಡಿ. ಅವ್ರಿಗೆ ಒಂದು copy ಕೊಡಿ. ಕೊಡ್ರಿ. ಇನ್ನೊಂದು copy ಕೊಡಿ.
Yes.
But matter arises not of the order the recovery officer not on the proceedings of DRT. But the recovery officer not held in favor of the present appellant not holding that we are not bound by the proceedings in the decree not which has been passed earlier. The Lord would find the order of the recovery officer not page 267. I should find out the operative portion not at page 273. May I just read not page 273 not at the operative portion. The Lord should find the typed copy not if the Lordship prefers not at page 285 not the Lord should find the typed copy not because there's some you just read that one, the operative portion. In the light of the relevant record, the evidence reduced by the respective parties in the respective submissions, it is proved beyond reasonable doubt that objectors 1 and 2 have business relationship. The mortgage created by objector 1 in favor of objector 2. Sorry. But in my writ appeal, if your lordship has page 285, that is writ appeal 741 of 2020. 285 type. Now, this was the order passed by the recovery officer on the objections that had been raised
by the present appellant as well as the other appellant. In the light of the relevant record, the evidence introduced by the respective parties and the respective submissions, it is proved beyond reasonable doubt that the objectors 1 and 2 have business relationship. The mortgage created by objector 1 in favor of objector 2 by deposit of original title deeds for the credit facility availed during the normal course of day-to-day business has been found to have been validly created, which is enforceable in the eyes of law, owing to non-service of, it should be non-service, not it's typed as in-service, non-service of order of injunction dated 18/6/1999 on corporate 4 by the prescribed modes of service and law. CH Bank failed to prove their right to proceed against the scheduled property before so when the said property has already been alienated. Thus, the order of injunction has become redundant. As a result, on the grounds of equity, the above scheduled limit property cannot be enforced in this recovery proceedings. Thus, the issues involved in this directions are answered. Accordingly, the attachment warrant issued by this authority against scheduled property has been recalled. But this was the finding of the recovery officer. Now, my lord, against this, my lord, the first respondent bank, my lord, preferred an appeal before the learned debt recovery tribunal, but not with delay. Not your lordship would find not they are supposed to have filed not within 30 days. They filed an appeal, but then not since it was delayed, they had filed an application for condonation of delay. Now, my lord, but thereafter, not the judgment of the Supreme Court came out, not which said that in view of the specific provisions under the DRT Act, there is no power not to condone the delay. Then, my lord, the bank withdraws not their appeal. The lordship would find that order, my lord, at page 260, my lord. What would find not let me just read not it all present. This SR is disposed of giving liberty to the bank so as to pursue its legal remedies as per the law by way of a suit or claim or otherwise before appropriate court of law against the CD objectors defendants as the law may permit. Not realizing that not their appeal was barred by time and that there is no provision for the DRT not to condone the delay, they withdrew the appeal. Now, my lord, after withdrawing this appeal, they file the writ petition, lord, directly challenging the order of the recovery officer. And that is the one, my lord, which has now been allowed by the order of the single judge. One of the questions, my lord, which you have raised is whether, my lord, if the statutory remedies were barred by time and having, my lord, explored those remedies and having found that, my lord, it is delayed and it could not be entertained, whether a writ petition could now, my lord, be used as, my lord, as a remedy to challenge the order of the recovery officer. That's, my lord, is the one of the questions which arises before the lordship's consideration, my lord. In fact, my lord, according to us, the judgment of the Supreme Court also would say, my lord, that if the statutory remedies are available and are not availed of or cannot be availed of on account of delay, then, my lord, the question of filing a writ petition would not arise, because, my lord, they would be then achieving indirectly what you could not do directly, what you sought to do directly.
There's a delay in filing petition.
Not in the filing the appeal before the DRT. And not the Supreme Court not came out to the judgment which said that the DRT has no power to condone the delay, just like in the Arbitration Act or other special statutes.
Which is that section here?
But that judgment of the Supreme Court, I'm sorry.
That we know, but here which is that section?
The recovery of debts due to banks and section 13. DRT.
30.
Recovery of debts due to banks and finance. Notwithstanding anything contained in section 29, any person aggrieved by an order of the recovery officer made under this act may within 30 days from the date on which a copy of the order is issued to him, prefer an appeal to the tribunal. On receipt of an appeal under subsection 1, the tribunal may, after giving an opportunity to the appellant to be heard, after making such inquiry as deems fit, confirm, modify, or set aside the so and so. Now, my lord, they did not, my lord, file the appeal within the time prescribed. And they had filed an application, my lord, for condoning the delay. Not the judgment of the Supreme Court, not in international asset reconstruction company. Not that had held that under not section 25 to 28, not there is no power to condone the delay. And therefore, not realizing this, they withdrew with liberty to file a suit or make other claim. And but then not filed a writ petition which has been entertained with the learned single judgment. Therefore, our submission is that the writ petition was not maintainable, not against the order after having it.
We'll continue. When continue? Yeah. 10 seconds.
Second, very well. But there was an interim order which was enforced.
No, my lord, no, only one request, my lord. As far as granting of, my lord, this property, my lord, was brought for auction. And they, my lord, they challenged that order and your lordship declined to grant any interim order. But property has already been auctioned, your lordship has already made an observation.
So whatever interim order is there.
On 9/5/2024, my lord, an interim order was granted saying, my lord, do not confirm, my lord, the
same.
It will continue.
That's
It
same
has-
order, my lord.
It has to continue.
No, the same order, no, the same, to the same extent.
Same. Interim if granted earlier, said to continue to operate in.
Your lordships kindly. Sorry. That's item 47, my lords. On the last occasion, my lordship had observed that if the matter doesn't reach, it'll take it up at 2:30. It's with respect to the appointment of nomination by the doctrine of pleasure, my lords. Identical matters are coming, one is coming up on Monday, my lords. The period also is over.
It is over.
The syndicate's period is also over, my lords.
We just
Nine
wanted a clarification, my lords.
Then what will?
Senior counsel is online, my lords, so the
My
same.
lords, we just wanted a clarification that the statutory provision would apply.
We'll take up when we'll take. Whenever time.
Tomorrow, my lords.
Fourth. Fourth.
Tomorrow, my lords.
Fourth. Tomorrow, not first.
I make a submission?
My lords, first matter, identical matter is coming on first, my lords, Monday. First. 2:30, my lords. Yes.
47.
No cheat, no memo.
That's 47, there's a connected matter.
Okay. Matter is going on. If it is over, we take the board. Special bench. Different act, same
Yes.
doctrine of pleasure.
Yes.
So once it reaches its logical end, it will be easier.
Yes,
to-
but here, my lords, in this matter, my lords, the term of the
Term of-
body itself is
First-
over.
First remind us, first.
Please.
Keep it.
Serial number 30, please.
Mm.